This is a meeting of the South Carolina Real Estate Commission, Wednesday, February the 25th. The time is 10 a.m. at the 110 Cedar View Drive, Kings Tree Building, Columbia, South Carolina. As public notice of this meeting properly posted at the South Carolina Real Estate Commission office, Synergy Business Park.
Yes, sir.
Posted on the Commission website and provided to all requesting persons, organizations, news media in compliance with Section 30-4-80 of the South Carolina Freedom of Information Act. Is that correct?
Yes, sir.
This time, I'm going to call on Commissioner Mitchell for our invocation.
Pray. Father, we come to you this morning in the name of Jesus, thanking you for this day. We pray your blessings upon this meeting as we go forward. We ask that you be with us and guide us as we make decisions that are going to impact us. We thank you for all who are here, and we ask, God, that you allow us to do things decent and in order. In Jesus' name we pray.
Please stand with me for the Pledge of Allegiance. Republic for which it stands, one. This time we will have introduction of our commissioners.
Tommy Dugas, public member.
Alan Wilkerson, 2nd Congressional District.
Stackhouse, public member.
Andy Lee, 3rd Congressional District.
Randy Duncan, Advice Counsel to the Board.
John Reinhardt, 5th Congressional District.
David Burnett, 4th Congressional District.
Janelle Mitchell, 6th Congressional District.
Gary Pickering, member at large.
Daniel Moskowitz, 1st Congressional District.
Erica Wade, Board Executive.
Ashlyn Brown, Administrative Coordinator.
Waddy Wharton, lead investigator, OIE.
Shannon Davis, Office of Disciplinary Counsel.
April Howe, Program Manager for Inspections, OIE.
This time, Ms. Wade, do we have any excused absences, or are we full? Thank you. You have before you, Commissioners, the agenda. If you would take a moment, we'll need a motion to approve the agenda or any changes that you may have to it.
Chair, I move we accept the proposed agenda.
Second.
Motion and a second. Any discussion on the motion? Hearing none, all in favor, let it be known by saying aye.
Aye.
You have before you the minutes of our January 21st meeting. Had an opportunity to review those minutes. Are there any changes, additions regarding the approval of the minutes? And if not, do I hear a motion to approve?
Chair, I'd make a motion to approve the minutes for January 21st, 2020.
Second.
We have a motion and a second. Any discussion on the motion? Hearing none, all in favor of the motion, let it be known by saying aye.
Aye.
I'd like to take a moment and welcome our guests this morning. We have with us Ms. Tiffany Lee, who is the teacher instructor of Clover High School real estate class. Ms. Lee, would you stand and you introduce the folks who are with you? Give them a welcome. Ms. Lee has graciously invited me to speak to this class on the 16th of this month, so I will be joining them at the Clover High School to answer questions and talk to them. This is the first of its kind. This is a 60-hour course on pre-licensing in South Carolina. So look forward to, and on behalf of the Real Estate Commission, welcome to you students. We're glad to have you. Thank you for coming. All guests this morning, a commissioner who is waiting on final from the state, and that is Drew Street. Drew, if you'll stand and be recognized, he's Commissioner 5th of the 7th Congressional District, and he'll be joining us full-time in March. Glad to have you, brother. The purpose of the South Carolina Real Estate Commission is to regulate the real estate industry so as to protect the public's interest, which is involved in real estate transactions. The Commission also investigates complaints and conducts application and disciplinary hearings in accordance with the state statutes and regulations. Our staff, I'm going to call on Ms. Howie, April Howie, for report.
Good morning, everybody. I have two reports for you this morning. The 2025 statistical report, just kind of wrapping up last year. Essentially, we have the total inspections since I last reported, which was 6, and then the total inspections for the year of 2025 was 185. And then the 2026 statistical report, we've had 50 inspections since the last time I reported. And so far this year, the number there is 44. I actually ran the numbers this morning. We have 60 as of today. So as you can see, we are increasing and prioritizing those inspections and getting them more frequently done. Happy to answer any questions you may have.
Any questions, Commissioner, for Ms. Howe?
Mr. Chair, Ms. Howe, just curious, are you finding any commonality and any problems, or is everybody doing a wonderful job, or are we?
Yes, to both. Honestly, the most issues that we are finding, or the common issues that we are finding, are with property management. Real estate has been, or sales have been pretty good. The inspections are going well. Time consuming, especially with those escrow accounts, going through those. But with property management, there are some pretty common issues that I believe you'll be seeing in the future through Wadi's team.
Any other questions? Not, I'll call on Wadi Wharton, Office of Investigation and Enforcement, for the OIE report. Mr.
Yes, sir.
Wharton.
Thank you very much. This is for your information. 2025, we received a total of, oh no, I've got the wrong one. I brought the wrong report down. I am sorry. For your information, from January 2nd, 2025 to February 17th, 2026, we've received a total of 837 complaints. We have closed 112 of them, and we have issued 9 citations. That is for your information.
Thank you, Mr. Wharton. From the Office of Disciplinary Counsel, the ODC report. Excuse me.
Yes, sir.
Excuse me.
We still have the IRC report, and this is for your approval. On February 11th, we held an IRC with Sarah Tackix, William Herlong, and Lorraine Harding in attendance. We have a total of 20 cases for your approval, 12 dismissals, 5 formal complaints, and 3 letters of caution.
Thank you, Mr. Wharton. Commissioners, you have the IRC report before you. Do you have any questions for Mr. Wharton?
Yes, Mr. Chairman, I have just a couple, and so, I'm sorry. I hate to do this to y'all, but if we have questions on this report, they do require us to go into closed session for that purpose. So have a nice room, I hope, next door that they can go to for just a moment.
All right.
I apologize, but that's the protocol we have.
We have a motion to go into closed session to consider the report of the IRC committee. We have a second. We'll be moving into closed session. We have a motion and a second. Any discussion? Hearing none, all in favor, let it be known by saying aye.
Aye.
In regard to the IRC report, do we have any other concerns, questions?
I'd like to make a motion at this time. The motion I'd make is that we go ahead and accept the IRC report with two exceptions. One would be case number 25-301. My motion would be to move that to a formal complaint so that they may seek a possible consent agreement. 25-642, I would actually move to have that case moved to the dismissal. So that would be my motion to move those two, change those two cases and accept the rest as is.
We have a motion. Do we have a second?
Second.
All in favor of the motion, let it be known by saying aye. Aye. So moved. Any other questions regarding that? If not, our executive report, Ms. Erica Wade.
I think you skipped
Oh,
me.
excuse me, ODC. I apologize. I
That's okay.
put my check mark in the wrong spot, Ms. Wharton. Thank you.
Shannon Davis on behalf of the Office of Disciplinary Counsel. This is for your information only. These numbers are as of February 11th of this year. We currently have 96 open cases. 20 are pending hearings and agreements. We currently have 8 scheduled for hearings, 1 pending closure. We have closed 8 since the last report and 8 thus far this year, and 0 are pending appeals. So I'm happy to answer any questions you may have.
Do you have any questions for Ms. Davis? Hearing none. Ms. Wade?
Good morning, Commissioners. The Commission's current account balance as of January 31st, 2026 is $4,596,354.66. Also, on Thursday, which is tomorrow, February 26th, the regulations will go to full Senate, and that hearing will be held at the Grissett Building at 9 o'clock, room 308. Just as another reminder, there's a special call meeting that will be held via WebEx on March 5th, and I think that's at 2 o'clock. If you are available, please reach out to Ashlyn to let her know so we can ensure that we have a quorum. And if you have any notes or comments or suggestions for the instructor, please let Ms. Joy Middleton or Ashlyn know so that we can compile the information and have it for the instructor. Also, another reminder, renewals start April 1st, 2026, and will run through June 30th, 2026. And also after July 1st, any licensees that have not renewed will go into lapse status, and therefore they will not be able to practice real estate. I know we talked about this earlier. If you haven't already done so, the newsletter is out. I want to thank Janina, our research assistant, and the rest of the staff for putting this together. It's going to be on our website, so if you click on it, it'll take you to exactly where it is. So the newsletter is a recap of our 2025 accomplishments, also all upcoming events that we have. And just as a quick reminder, the Instruction Development Workshop, the IDW, will be held May 6th and June 9th of 2026, and that's the Commercial Core Course. The Commercial Core Course will be April 15th through the 12th, and the IDW is May 6th and June 9th. And correspondence have been sent out about those workshops. And with that, any questions?
One quick question with the newsletter, how often does that?
We want to try to get them out quarterly.
Quarterly.
Yes.
Questions for Ms. Wade? Hearing none, move the meeting into the formal complaint hearing. This hearing is called to order. This is a disciplinary hearing in the matter of Craig McGee, case number 2024-255 and 2025-243. Do any commission members need to recuse themselves from hearing this matter? Hearing none, hearing is being held in accordance with the provisions of the South Carolina Administrative Procedures Act and the statutes and regulations of the South Carolina Real Estate Commission. My name is John Reinhardt, and I am Chairman of the South Carolina Real Estate Commission. The attorney assigned to advise us during the hearing is Brandy Duncan, Advice Counsel with LLR. Shannon Davis, Disciplinary Counsel with LLR, represents the state. Were the pleadings furnished to each member of the commission?
Yes, they were.
Wade, is the respondent present?
No, sir, Your Honor. Or, Mr. Chair.
Davis, can you provide proof that the respondent was properly served with the notice of this hearing?
Sir, and I'm going to enter the cover letter, notice of hearing, formal complaint, certificate of service, a copy of the certified mail green card, as well as the certified mail that was returned to sender, and a copy of an email that was sent to Mr. McGee reminding him of the hearing. We have not heard anything from Mr. McGee, so I'd like to make this packet Exhibit Number 1, and I have copies to pass out to everyone. Mr. McGee was served by regular mail and certified mail with return receipt requested of the notice of hearing and formal complaint, which was scheduled for February the 25th of 2026 at 10 a.m. in the King Street building. The address that was sent to is 195 Empyrean Circle in Myrtle Beach, which is the same address that is listed on his credentials and relays. The notice of hearing did inform him in paragraph 3 that the hearing could go forward if he failed to appear. The certificate of service showing that this was mailed was signed by my paralegal, Ms. Kimberly Long, certifying that she had served it upon him on December the 25th. And you will see on the next to last page that we did get the certified mail was returned to sender unclaimed, unable to forward. And then the last page is the email that Ms. Long sent reminding Mr. McGee at both of the email addresses that he has listed in relays on Tuesday, February the 10th, reminding him of this meeting. She sent it as high importance. She attached a copy of this packet for him, and my office has not heard anything from Mr. McGee. So I would submit that the state has proven proper service of the notice of hearing and formal complaint in this case, and would ask to go forward with this case at this time.
So accepted. Go forward, please.
Just very quickly, for the record, did the mailing with the regular mail, was that also returned?
That was not returned.
And can you explain what Relays is briefly?
I'm sorry. Relays is the system in which all of the licensees' contact and credential information is uploaded. That is the licensee's requirement to make sure that their contact information is uploaded. It's their duty to make sure the proper information is provided, and that is where we get all of the contact information, comes directly from the licensees to the commission. So that's the information they provide the commission with, where they can be contacted, and that is what was used for service in this case.
And just as a follow-up, when they do move, how long do they have before they have to have that information updated?
I'm being told 10 days. So I would ask that State's Exhibit Number 1 be entered at this time.
Yes, please proceed. For the record, I find that service was made and proper, and that we're going to move forward with this hearing.
Thank you, sir.
I'd like to go ahead and present.
Would you like me to start with an opening? It'll be
Please.
very brief.
Please.
In this case is the matter of Craig McGee, real estate license REL 55942. He is a property manager in charge. There are two cases being alleged or being prosecuted today against him. The first being 2024-255 and the second being 2025-243. You will hear from both of the investigators in these cases about the documents that they collected and the communications they had with the complainants in this case. You will also hear from them, which is, I believe, is most importantly, are all the efforts that they made to attempt to contact Mr. Healy and serve him with the notice of complaint. And he did not respond in any way. He has not responded to the notice of complaint. You will hear that from the investigators. From the homeowners, you will hear that Mr. McGee was the property manager for two separate homeowners, the first being Mr. Healy on the case 2024-255, and the second case being Ms. Michelle Wright, 2025-243. The allegations are essentially the same in both cases, that he was the property manager. They had an agreement for him to pay them, the rental proceeds and the security deposits from these rental properties, and that he failed to do so after a certain amount of time. For Mr. Healy's case, it was for the period of August 2023 through January 2024, where you'll hear that he owes Mr. Healy approximately $8,400, and Mr. Healy has had to attempt to go forward with the civil case to try to collect this money. You will hear from Mr. Healy's case that he failed to collect security deposits from tenants and allowed a tenant to move out of the property with no notice and no penalty, which was in violation of the agreement. You will also hear regarding Mr. Healy's case that the respondent allowed a tenant to tear out carpet damaged by a tenant and replace it with vinyl flooring in lieu of paying rental payments. And this was done without Mr. Healy's approval. You will hear from both of the homeowners that they made multiple attempts to contact Mr. Healy, and he essentially went MIA, just like our investigators found. That's why they filed the complaints in these cases. And you will hear from both of them as to the efforts that they've had to make to try to recoup this money. So that will be what you will hear in this case. So if I may call my first witness. That will be Mr. Chuck Waters. He's the investigator on case 2024-255. And Mr. Chair, what I plan to do is call my witnesses for the first case, 2024-255, then immediately call my witnesses for the second case, if that's okay with you all, since the allegations are essentially the same, and then have you make a ruling at that time.
Please proceed.
Okay, thank you. The state would call Chuck Waters, please. Mr. Waters, where are you employed?
The South Carolina Department of Labor Licensing and Regulation.
And what is your position there?
Investigator.
And what boards or commissions do you investigate for?
The Real Estate Commission.
Okay. And how long have you been doing that?
About 3.5 years.
And what are your duties as an investigator for the Real Estate Commission?
To gather evidence, research, essentially just run down allegations that are submitted for complaints.
Okay, when you receive a complaint, is that something that's assigned to you?
It is.
Okay. And when you receive a complaint, kind of take us through the steps of how you investigate the cases.
So when we receive the complaint, typically we'll contact the complainant to get their side of the story. All the while in the background, we're doing research on the respondent, trying to collect as much evidence from the complainant as possible before we actually notice the respondent.
Okay, and in this case regarding the respondent, Mr. McGee, did you reach out to the complainant, Mr. Healy?
I did.
Okay, and were you able to get any documentation from him?
I was, yes.
Okay. Did you attempt to contact Mr. McGee, the respondent in this case?
I did.
And please tell the commission about your attempts to contact him.
So initially, we issue what's called a notice of complaint, which spells out the complaint allegations, and that is mailed to the address provided by the respondent.
And where do you get that address from?
Relays.
And tell us a little bit about what that is.
So that's an internal database for the licensing for licensees. So it houses their contact information, their licensing information.
And whose duty is it to keep that information updated?
The licensee.
Okay. And so you said you mailed him a notice of complaint. What, if anything else, did you do to attempt to contact Mr. Healy?
So initially,
I'm sorry, Mr. McGee.
initially we mail the notice of complaint. Sometimes, depending on mitigating factors as far as caseload and things of that nature, we'll immediately send an email. Sometimes we'll wait on the notice of, or wait on the response from the mailed notice of complaint. In this case, it was done just like that. The notice was mailed and then emailed.
How long set forth in your notice of complaint that the respondent has to respond?
14 days.
Okay. And did you receive a response from Mr. McGee within 14 days of mailing your notice of complaint?
No.
Okay. What, if anything else, did you do to attempt to contact him?
So at some point, I located an office address. I believe it was from his website, mailed another notice to that address. After not receiving any response to that, I made a trip to his current office location and home address.
And were you able to make contact with him at either one of those locations?
No.
Was the office address where you went, was it still in business?
It was not.
Okay. Did you make any other attempts to get in touch with the respondent in this case?
Telephone, text message, and a third notice of complaint was mailed to at some point in time, he added another address, so a third notice was sent to that address.
I'm going to hand you what has been marked as State's Exhibit 2, and you can tell me if you recognize these documents. Just for the record, this exhibit has been bait stamped, and it's pages 1 through 105. Do you recognize these documents?
I do.
And are these the documents that you compiled in case 2024-25? Yes, 254-255?
They are.
Okay. Are they kept in the ordinary course of business?
They are.
At this time, I would move State's Exhibit Number 2 into evidence.
So moved.
Thank you.
Okay, Investigator Waters, pages 1 through 3 Tell us what those are.
So page one would be the contact view screen. It lists the licensee's main or mailing address, contact information, email, phone.
And is this in a contact view screen from the Relays program that you discussed previously?
It is.
And these addresses and emails are provided by the respondents?
That's correct.
Okay. And going to page 2, what is this?
This is an expanded view of the credential screen. It lists the type of license, any office that is supervised by that licensee.
Okay, and tell us what type of license Mr. McGee has?
It's a property manager in charge.
And what is his credential number?
55942.
And the PIC, that is the property manager in charge?
That's correct.
And when was his license first issued?
November 30th, 2005.
And what is his current credential status?
That's active.
Okay, and what office does it show that he supervises?
Atlantic Real Estate Management,
And where is that located?
Myrtle Beach.
Okay. And the information listed here would be where you attempted to contact him.
That's correct.
Thank you. Going to page 4 through 7, can you tell us what that is?
This would be an audit trail for his credential.
And what does that show?
It shows any changes, i.e. the change in office, change in license status, whether his license is active or in renewal, just various other factors that follow the license.
And do you see any recent updates to his address or contact information in this audit trail?
No.
It would look like the most recent update for contact information would be on page 4 at the bottom, him updating his email addresses, and that would have been August the 25th of 2020. Is that right?
That's correct.
Thank you. And moving to page 9, and for the commission and for the record, within Exhibit 2, which is this entire packet, there are multiple exhibits. And I'm going to have Investigator Waters go through what each of those are, but I just wanted to clarify. The list of what the exhibits are is on page, base stamp page 8. So let's go to what is listed as Exhibit number 1. That would be pages 10 through 12. Tell us what this is.
This is an initial complaint form. This provides the complainant's information, the respondent's information, and then a brief summary of the complaint allegations.
Okay, and who made the complaint in this case?
Douglas Healy.
And just briefly, what were the allegations of his complaint?
Essentially that Mr. McGee failed to provide or remit rental proceeds, security deposits, and failed to continuously communicate with Mr. Healy.
Okay, and this would be the complaint that was assigned to you as 2024-255.
That's correct.
All right, looking at Exhibit number 2, which would be pages 14 through 15, can you tell us what that is?
This would be the property management agreement between Mr. Healy and the respondent's real estate office.
Okay, and did you receive a copy of this from Mr. Healy?
I did.
Okay. And what is the date of the agreement? You're looking at page 14.
So June 22nd of 2020.
Okay. And the parties listed are Mr. Healy and then Atlantic's Real Estate?
Atlantic Real Estate, yes.
And is that the brokerage that the respondent supervises?
It is.
And what is the property location that this agreement is for?
It's Unit 60D, 492 River Oaks Drive, Myrtle Beach, South Carolina.
Okay, and in paragraph A of base stamp page 14, does it set forth the collection and disbursement for the rental proceeds?
It does.
And does it state that it would be paid to the owner on or before the 15th day of the current month if the rent has been received from the tenant?
It does.
Flipping to the next page, what were the dates that the agreement would be effective for?
June 22nd of 2020 through August 31st of 2021.
And was this agreement automatically renewed and extended unless terminated in writing by the parties?
It was.
Okay. And who signed as the owner?
Craig McGee. I'm sorry, Douglas Healy is the owner, yes.
And who signed as the, I believe it's listed as manager, but who signed as the broker in this case?
Craig McGee.
And that would be on behalf of Atlantic Real Estate Management?
Correct.
Going to exhibit number 3, which would be pages 17 through 21. Can you tell us what this is?
This would be email correspondence between me and Mr. Healy, where he is essentially outlining his, what he says he is owed as far as rental and security deposits. And he also goes into a narrative as to what happened as far as tenant 1 leaving, tenant 2 coming in.
Okay, so this is essentially a supplemented version of Mr. Healy's complaint with, specifics.
It is, yes.
Okay. And it looks like what Mr. Healy is stating is that the failure to remit rental proceeds started in August of 2023 through January of 2024.
That's correct.
And the total amount that he lists as due is $8,400.
Correct.
Does he also discuss his attempts to contact Mr. McGee about his issues?
Yes.
And also discusses the vinyl flooring being installed without his knowledge?
Correct, yes.
And a missing security deposit?
Correct.
Okay, going into exhibit number 4, I believe that's pages 23 through 70. And obviously, we won't go through all of these, but who did you receive these from?
Mr. Healy.
Okay, and what are they?
Essentially, text messages to, and I'm assuming it could be from Mr. Healy's spouse. Well, there were 2 different ones, but they were essentially text messages to Mr. McGee regarding the security deposits, the rental proceeds, and the failure to respond.
So this shows his attempts to get to inform the respondent of the issues he was having and to get those resolved.
That's correct.
Okay. Right, and we'll move to Exhibit 5 within what's been entered as states Exhibit number 2. That is page 72 through 88. Can you tell us who you got these from?
Mr. Healy.
Okay, and I know they look to be photos, but are these photos of the subject property?
They are.
Okay, and what are they showing?
Front door, some vinyl flooring, various items that appear to be left in the condo, and some damage to the screen on the rear porch.
And is exhibit number 6, which we will, is base stamp page 90. Who did you receive this from?
Mr. Healy.
Okay, and what does this show?
This would be a receipt for the security deposit.
And showing that there was landlord insurance being paid?
It does.
For this property?
It does.
We'll take it to Exhibit 7 within State's Exhibit Number 2, page 90 through 96. Can you tell us what these are?
These are correspondence from Mr. Healy to Mr. McGee, essentially putting him on final notice and outlining what rental proceeds and security deposits he was due.
So these are his attempts to inform Mr. McGee of the problems he was having and to have that resolved?
That's correct.
Okay. Go to Exhibit Number 8, which is page 97. $105. Tell us what this is.
This would be the notice of complaint sent to Mr. McGee.
And what is the purpose of sending a notice of complaint?
It outlines, well, number one, it notices that there was a complaint filed, but it also spells out the allegations and to provide a written statement within 14 days along with any other documents that are requested.
And did you request documents from Mr. McGee in this case?
I did.
And did you ever receive those?
No.
Okay. And what are the attachments to the notice of complaint? Oh, I'm sorry. So that would be the first notice of complaint. And when was that sent?
March 22nd, 2024.
Okay, and this is sent to a Broadway address. Where did you get that address?
That would be what was the address that would be provided in relays. These are generated forms.
Okay. All right, let's go to page 99. When was this notice of complaint sent?
This one was May 29th of 2025.
And where did you get the address that this was sent to?
This would be another address that was from relays.
Okay, and did you receive any response to, within 14 days or otherwise, to this May 29th notice of complaint?
I did not.
And attached to that notice of complaint, it looks to be the initial complaint that was filed against him, along with a copy of the agreement. Why notice of complaint?
Any documents that we receive with the initial complaint are provided to the respondent with the notice.
And in addition to sending those notices of complaint and receiving no response, you made an in-person visit to his home address as well as his office address and text messages and calls and emails, and you were unable to get in touch with him.
That's correct.
Has he cooperated with this investigation in any way?
He is not.
Thank you. That's all the questions that I have for Investigator Waters. Please answer any the commission may have for you.
He never responded to any,
He did not.
zero response.
No response.
Other? I'd like to call your other witnesses.
Does anybody else have any questions for Investigator Waters? May he be excused, please.
Yes, he may.
Okay, my second witness is Mr. Doug Healy, and he is on WebEx, so you'll be able to see him on the screens around the room.
Mr. Healy, can you confirm that you can hear us okay?
We cannot hear him. Mr. Healy, I think that you're muted.
All right. Can you hear me now?
Yes, sir, we can.
Okay, very good.
And I think he needs to be sworn.
Sure.
Only swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Well, thank you.
Is it possible to turn up the volume for Mr. Healy a little bit, or is this as loud as it gets? Okay, thank you. Mr. Healy, that's not on your end, that's an us thing.
Oh, sorry.
Thank you.
Are we good? Thank you. Mr. Healy, where do you live?
My primary residency is Lincoln Park, New Jersey, 175 Susquehanna Avenue, Lincoln Park, New Jersey.
And what do you do for work?
Actually, I just started a new job. I am a banker for a casino in New York.
All right.
Before I used to be in forklift sales, but my company got bought back in September and they let half of the staff go.
And at some point, did you own property in Myrtle Beach?
I have owned it since 2005.
Okay, and what's that property's address?
492 River Oaks Drive, Unit 60D, Myrtle Beach, South Carolina.
Okay, and at some point, did you hire Mr. McGee to manage that property for you?
Yes, I did. Actually, that was in June of 2020.
And that was for the same property that you just described?
Correct.
Okay. And based on your agreement with him, was he supposed to submit rental proceeds to you on or before the 15th of each month?
That is correct.
And at some point, did you start to have problems with Mr. McGee and his management of your property?
Yes. It's around May or June of 2023, where there was limited communication with him. He wouldn't respond back. And then we didn't receive payment on the rental, the proceeds, the rental proceeds. And so between my wife and I, we reached out to him numerous times, and it just, every month, he said, "Oh yeah, I'll get to it. I was out of town," every excuse in the world. But yes, it started to have problems around June, July of 2023. It was it initially started.
Okay, and do you recall sending an email to Investigator Waters in this case, essentially setting forth all of the allegations that you had issues with the respondent?
Oh, I sure do. Yes.
Sure.
Absolutely.
And I believe that you listed the first month's rent, that rental proceeds that were not submitted to you would have been August 23rd. Does that sound correct? August of 2023. I apologize.
Correct. Yes.
And that would have gone through August, September, October of 23, November of 23, December of 23, and then January of 2024. Is that correct?
Correct.
Okay.
That's correct. Yeah.
So tell the commission what efforts you made to get in contact with Mr. McGee to resolve these issues.
I was just looking through this paperwork. I must have sent him more than a dozen emails, text messages between, I sent to him well over 24 text messages. The same with my wife from her phone. The last communication, he gave every excuse in the world that, he couldn't pay. Oh, I was out of town. I had a death in the family. These things happen. It's part of reality. But he, in one of the emails dated back from January 29, 2024, he said he had an employee involved in theft of funds at his company between August and November 2023. I not sure if it's 100% true. Every attempt possible. He stated in this email that I have full intention to pay you back. That never came. One of the things he also mentioned was for the insurance liability. It's insurance for any damages that exceed the security deposit, in which this substantial damage, and he assured me he would open up a claim, which I checked with the insurance company. He did not.
Okay. At some point, did Mr. McGee just quit responding to your attempts to contact him?
Yes, that was in the last response we got from him was on January 29th. We reached out to him continuously through into March of 2024 and no response. At that point, I had no further choice. I said, okay, let me take some action. That's when I reached out to your office and, had communication with Mr. Waters.
Okay. So it looks like there's multiple complaints essentially, or multiple complaints within your complaint. So let's start with the first one, that he failed to disperse rental proceeds. And I think that we discussed that the months that he failed to give rental proceeds to you. And for the commission in states that number 2, it would be based on page 17. That is rent $1,200 for a security deposit. September of 23, security deposit. September of 23, rent of $1,200. October, $1,200 rent. November.
Correct. Yeah, I found out. Part of it, what you were saying, was breaking up on my end. It wasn't communicating through clearly. He never collected security deposits from the previous tenant, and then the tenant who moved in. Craig told me that the tenant was moving in the middle of October of 2023, when in fact I found out the tenant moved in September 1st. And he offered him free rent to rip up the carpeting, replace the flooring, which I don't know if the flooring. I mean, I've put flooring in, but this is a total hack job. I mean, it's horrendous. And he didn't have permission or any kind of. He didn't communicate with me. He was going to do this.
Sorry, my microphone is acting up on me.
Oh, that's good. That's much better.
Okay, good.
I'm sorry. Could you repeat what you were saying before?
Sure. So we discussed the rental proceeds and the security deposit proceeds that he failed to return to you. And that would have been about $8,400 starting in August of 23 through January of 24. Is that right?
That's correct.
Okay. Then I think another allegation that you made against him is that he failed to collect security deposits from tenants and allowed a tenant to move out of the property with no notice and without penalty.
Oh, yeah.
Can you tell the commission
That's
about
correct.
that?
Yeah. The tenant moved out. That was in June of 2023. And I said, okay, well, obviously then he forfeits his deposit. And he didn't tell me at first that he didn't collect a security deposit from the tenant who moved in. The same tenant who destroyed the carpeting. That carpeting was only at that point only 2.5 years old, and destroyed the kitchen. I mean, I had the whole kitchen redone, countertops and new facing on the cabinets and everything. I said, okay, and he at first didn't, I had to like pry it out of him I said, can you go into the unit and take photographs, and anything that you see, any repairs that need to be done. And he was reluctant because at that point, he had already, I had gotten the photographs from him. And at that point, I said, you have to file a claim. Please open a claim.
And what type of claim are you referring to?
An insurance claim for the landlord liability insurance.
Okay, so you
And he
asked him,
assured me.
I'm sorry, I don't mean to speak over you. So you asked him to file a claim with the insurance company. Are you having trouble hearing me?
Yes, I am. It's not coming through clear. It's breaking up.
I'm not touching them. Okay. Now, can you hear me now?
Oh, yep.
Okay,
Loud and
we're
clear.
going to go through every microphone in this room, but we'll get it done.
No.
All right. Now I'm trying to remember what I was talking about. Oh, the insurance. Please.
Insurance.
So you asked him to file a claim regarding the carpeting that was destroyed. Did he ever file that claim with the insurance?
No, he did not.
Okay. And I think that you said that he failed to collect a security deposit from that tenant and allowed a tenant to move out with no notice without penalty. Is it your understanding with your agreement with him that he was supposed to collect security deposits for each new tenant?
Yeah, he's supposed to collect a security deposit with every new tenant, and he never he never checked with me to get that authorized or permission with me.
So you never approved him doing either of those things?
No.
Okay.
No. And you never let anybody move in without a security deposit.
And you never gave him permission to allow a tenant to move out without notice and without penalty?
Absolutely. Yes, that's correct. No, he did not tell me any of this. I might want to add, I reached out to the insurance company on my own, Great American, and there was an active policy in which I received an email. I checked with, received an email from Kevin Humbert of Great American, who holds the policy. He said that Craig McGee declined to open up a claim. And the policy is valid and it's active, so I don't know why you would not, but he said I couldn't open it because I'm not the policy holder. Craig McGee of Atlantic Real Estate is the only one who was authorized to do that, so.
And you asked him to do that?
Yes, and in fact, in his last email to me on January 29th, I sent you a copy of that email. And he said he was going to, let me say, he says, I'll read it, we have filed an insurance claim for this incident and we are currently awaiting for the insurance company to pay the claim, which is a lie because I checked with the insurance company and, the insurance company reached out to him and said, do you want to open up a claim? And the insurance agent said, no. Greg McGee declined to open up a claim.
Okay, I think another complaint that you made against Mr. McGee is that he allowed a new tenant to tear out the carpet that was damaged by the other tenant and replace it with vinyl flooring in lieu of paying rental payments. Did you give him approval to do that?
No,
Did you know that he
No.
was allowing them to do that in lieu of payment and to make those, I guess, home improvements without your knowledge?
no, I did not.
And did you want vinyl flooring put in your property?
No.
And the photographs that you sent that are part of State's Exhibit Number 2, does that show the vinyl flooring that's at issue here?
I can't see it from my end, but I know like the vinyl flooring, it wasn't quality. In fact, even the parts of the vinyl flooring where it's supposed to match up to the edge of, let's say, the kitchen tiling, it doesn't even match up. It was a hack job. I mean, I've put in vinyl flooring on one of my other houses here in New Jersey. That's unprofessional the way it was done. And you can see there's problems actually happening with that. I did not authorize that or even have knowledge of it being done.
In addition to the failure to remit the rental proceeds to you and the money that you're out there, I believe, which is around $8,400, have you had to pay for things out of pocket as a result of your dealings with Mr. McGee?
Oh yeah, I mean, besides of if I can't open up an insurance claim, yeah, it's going to cost me, you know, thousands of dollars to have the work be done and done correctly. And, you know, which kind of retorts back to the fact that I was paying insurance. It's not much, it's $10 a month, but every month, you know, you're paying for this insurance and it's not being used. What was the point of it? Or what happened to that money? Yeah, it looks like it's estimated. The last time I had it done was done by Q Kitchens. You know, it was somewhere around like $5,300. I mean, that was in 2020. So it's going to be somewhere around like to put recarpeting and then kitchen repairs to the kitchen cabinets and everything. Yeah, it's up there.
And have you filed a civil lawsuit against Mr. McGee to attempt to recoup your money?
I have.
And is that still pending?
Yes, that is coming up probably in May or June. And yeah, it was supposed to be in February, but I had just started a new job 2 weeks ago. So I had to ask them, request them to push it back, which they were able to do so. I might want to add, at the address at 195, he was actually, the sheriff actually issued him a summons and had him sign for the summons right there for the civil suit at his home address.
And issues that you had with Mr. McGee that you want to share with the commission?
It started out good, and all of a sudden it just went, you know, for a couple of years. And all of a sudden it was just, he just disappeared, you know, not responding. You go months without responding, weeks without responding, trying different phone numbers to, you know, get him at. Rather than me texting him, I'd rather have, you know, maybe my wife will text him. He won't recognize the number, and just on and on, you know. It's totally unprofessional. You know, besides of, you know, the guy's, I don't know, I'd put it anyway. It's, the guy must be like a thief or something. I don't know. How do you just explain like, oh, I'm not going to pay you? Yeah. So.
I understand. Well, Mr. Healy, thank you for being here today. Please hang on and answer any questions that the commissioners may have for you, okay?
Thank you.
Mr. Healy, just to confirm, you never did receive any of the money that was owed to you by?
No.
You sustained substantial property damage at the hands of this property manager, is that correct?
Correct, yeah.
Okay. And he failed to collect the earnest money, which he was required to do as per his contract, is that correct?
That's correct, yeah.
Any other questions, Commissioners? Hearing none, thank you, Mr. Healy.
Okay.
Yes.
Healy, can you hear me?
Yes, I can hear you.
You've been excused. That way you can go ahead and get to your new job
Oh,
today.
I'm sorry, I didn't hear you clearly. Okay.
No, that's
Thank you very
okay.
much.
We know we're having microphone
Yeah.
issues. Thank you so much for being with us today and providing your testimony.
Thank you for your time and your assistance. Take care. Bye-bye.
Chair, I'd like to put this out there just possibly to save some time and energy. If we could possibly go ahead and vote on, once the state, of course, is finished with the 2024-225, before we move to the next, could we go ahead and take a vote on this one to determine whether the presentation of that is necessary?
Sounds good. Oh, well, now it's working. Okay. Oh. Yeah, it doesn't want to hear from me. I don't know what's going on. And that would be all the witnesses the state would have for that case. And I can do a brief closing if you all want to hear from me. Sure. You have all the documents. You heard from Mr. Healy. He trusted Mr. McGee to manage his property. He lives in New Jersey, and he hired someone in state to take care of his South Carolina property. You heard that he was not remitted the rental proceeds like he was supposed to be. Mr. Healy tried to contact him numerous times to work out these issues. There were excuse after excuse, and then Mr. McGee went MIA on him. He essentially stole this money from Mr. Healy and has gone MIA, not just to Mr. Healy, but also to our investigators. He did not cooperate with the investigation in any way, despite Investigator Waters' multiple attempts to contact him. I'd like to give him kudos for going out of his way, because he could have just sent one notice of complaint to the address that was on relays and left it at that when he didn't hear. But he sent multiple notices of complaint. He went down there in person to multiple addresses to attempt to, speak with Mr. McGee and was unable to do so. We have heard nothing. Once this case was sent to me in Office of Disciplinary Counsel, I've heard nothing back. And I think that he is just showing a complete disregard for his duties as a real estate professional. And I think that the state has set forth beyond a preponderance of the evidence that he is in violation of the statute set forth in the formal complaint, those being 4057 710A5, in that in the practice of real estate, he has demonstrated bad faith, dishonesty, untrustworthiness, or incompetency in a manner as to endanger the interests of the public. You heard that he stole from the public member. As to section 4057 710A11, in that within a reasonable time, he has failed to remit trust funds coming into his possession which belong to others. As to 4057 710A25, in that he failed to cooperate with the investigation and did not respond to the investigator's request for a response or documents. As to section 41110-1F, in that respondent committed a dishonorable, unethical, or unprofessional act that is likely to deceive, defraud, or harm the public. You heard the testimony from Mr. Healy. And section 40-1-1101G, in that he lacks the professional or ethical competence to practice the profession or occupation. I don't think that the commission wants to set the standard that thieves are allowed to continue to practice real estate. And I would submit that I believe that Mr. McGee's license needs to be permanently revoked so that he is not allowed to endanger any other members of the public, take advantage of them, or steal their money. And that would be all from the state.
Is there a motion to go into executive?
Brandy.
Is there a motion?
I'd like to make a motion for the disposition of this case. I'd like to make a motion that we permanently revoke the defendant's license or respondent's license, I believe, beyond preponderance of the evidence that the state has proved 4057-710A5, 4057-710A11, 4057-710A25, 40-1-110, I think that's an F or 1F, and 40-1-110-1G. I would also like to impose a $3,000 per violation fine for a total of a $15,000 fine. So in summary, it's a permanent revocation, $3,000 per violation fine for a total of $1,000.
120 days. You've heard the motion, Commissioners?
May I
Yes.
ask one clarification? The significant misconduct that's happened in this case. Did you also want your motion to include a request for a temporary suspension order to be issued immediately by staff, signed by the commissioner and served by staff so that we can go ahead and shut his operations down?
5 minutes of our please. Yes, so temporary. Signed by Mr. Chairman.
We can do that, probably not within 5 minutes, but it will be done in all. All right, we have a motion, we have a second. Any discussion, Commissioners, on the motion? Hearing none, all in favor of the motion, let it be known by saying aye.
As it seems to be irrelevant to have a hearing now since he never has a license.
If I may have a moment to get with Miss Michelle Wright, she's my witness on the next case, just so I can explain a little bit to her, if I may have a few minutes for that.
Time to do that, and then we'll back again. Thank you.
Yeah, because, I know.
Check, 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 check.
That's the only way you can know
Before the commission moves into its next case, we're going to take a 20-minute lunch break. We will reconvene at 12:10. Excuse me, you had a comment before we take a lunch break?
I just wanted to say that I did speak with Ms. Williams, who was the homeowner in the second case for Mr. McGee, and she wanted to say thank you very much, that that was what she was hoping would happen, so she had no problem, driving up here to tell you what happened, but she is very happy with the result, and she thanks you very much.
Thank you, Counselor.
And Chairman, just very quickly before we do start the lunch break, for our students who are in the back, I just wanted to explain very briefly kind of what just happened in case any of that was confusing for you. So we had, our version of essentially a trial about the allegations of misconduct against Mr. McGee. Frequently, this commission will choose to go into what is called executive session with me to receive legal advice because I'm the attorney for the board. In this case, because the allegations were so abhorrent and the violations were so obvious, they obviously did not need that to make their motion as to what they thought should happen with regard to Mr. McGee's license in this case. And there are two different kinds of revocation in this state. For this licensing board, there's permanent revocation, which means exactly what it says. You are out of this industry for forever. And then there's non-permanent revocation, which is you're out definitely for at least 3 years, and if you ever want to come back in, you have to reappear before the board. So Commissioner Pickering's motion was for permanent revocation because the violation in this case was so horrible. And then, of course, he moved to also put a $3,000 fine on each of the 5 violations for a total of $15,000. Stiff penalties, but definitely appropriate in this case. So just wanted to share that with y'all so that if there was any confusion about what had just happened, hopefully that helped with that.
Let me put a PS on just continuation of what Advice Council said. With the update of the licensing law, which took place on May the 24th, 2024, effective May 24th, 2025, the commission has authority up to $10,000 per violation for each violation. In this case, should the commission choose to do so, they would be limited because the top amount was $5,000 prior to the update of the license law. So just for your information, any case after that time could be a $10,000 per violation. Any other comments, Commissioners?
Just two things. One, I'd like to at some point, I want to make a motion, we go into executive session for lunch, so we have some matters we could probably knock out. And secondly, I want to make sure our students have something available for lunch. I hope they're not just eating crackers. They have lunch?
Brought
Okay.
the lunch, okay.
Good. I just want to make sure they get something to eat, because it's a long day.
All right, in that case,
All right, so I'd like to make a
your
motion, we move
to
into
go
executive session for lunch.
Okay. And we will reconvene in about 20 minutes. Thank you. We'll call you. disciplinary hearing in the matter of Heidi Arovic-Cook, case number 2024-846, being held on February the 25th, 2026. Do any commissioners need to recuse themselves from hearing this matter? This hearing will be conducted as informally as is compatible with an equitable presentation of both sides of the case and in compliance with the provisions of the Administrative Procedures Act and the Commission's statutes and regulations. Everyone's reminded that these proceedings are being recorded, that all witnesses must be sworn before they testify. My name is John Reinhardt, and I am Chair of the South Carolina Real Estate Commission. The attorney advising the Commission is Brandy Duncan. The state is represented by Shannon Davis, Disciplinary Counsel. Ms. Arovic-Cook, are you represented by counsel? No. You understand that you have the right to be represented by an attorney of your choice in this matter? You are electing to waive that right and represent yourself. Is that? My understanding that the parties have entered into a memorandum of agreement. Is that correct?
That's correct.
Further, it's my understanding that the parties have agreed to the facts of the MOA, and the respondent has admitted that her actions have violated 2 statutory provisions. Is that correct?
That's correct.
Is that correct? Yes, ma'am.
Ms. Cook, if you would please speak into the mic so we can hear
Yes,
you.
there's some clarifications that I wanted to make with regard to the agreement. So that's why I'm here today, is to go through those.
And I explained to Ms. Cook that she would have an opportunity to address the commission and give you all any information or mitigation that she felt was important in this case.
Is that agreeable with you?
Yes.
Mayor Council will present the MOA, and the respondent would be allowed to address the commission in regard to that.
Thank you, sir.
Counselor.
We are here in the matter of Heidi Cook. Her license number is REL 37427. She is a property manager in charge. This is case number 2024-846. Again, the parties have entered into a memorandum of agreement and a stipulation of fact that the state would move into evidence as State's Exhibit Number 1. It's my understanding that the commission has been provided a copy of this with their materials ahead of time. But if anybody needs a paper copy, please let me know, and I'll be happy to pass one up.
Before we move on, I just want to make sure that if there are any witnesses that need to be sworn in, including the respondent.
No, I don't.
Just Ms. Cook.
Swear in, Ms. Cook. Please proceed.
Thank you. Ms. Cook is duly licensed by the Real Estate Commission as a property manager in charge and was so licensed at all times relevant to the issues in this case. She was first licensed by the commission on May the 29th of 2002, and she supervises property management services provided by Heidi, located in Port Royal, South Carolina. Pardon me. She has no disciplinary history with the commission. You will see set forth in paragraphs 4 through 9 of the agreement that Ms. Cook and the complainant in this case had multiple interactions regarding the complainant attempting to reserve a property from Ms. Cook for, I believe, a vacation rental is what she was attempting to schedule with Ms. Cook. And paragraphs 4 through 9 set forth their correspondence in detail, but I'm going to move on past that to on or about October 14th of 2024. The respondent sent the complainant some photographs of available property.
Ms. Davis, can you hold on for just 1 second?
I'm sorry.
I've just been reminded that we apparently never moved to come out of executive session. Are we off of YouTube right now? We are in open session? Okay. Could I hear a motion to come out of executive session immediately upon us coming back from lunch?
Remain where we are in this case.
But no decisions were made.
And remain where we are in this case.
Yes, sir.
We have a motion. Do we have a second? We have a second. All in favor of the motion, let it be known by saying aye.
Aye.
Thank you. Thank you for that.
Thank you. I'm so sorry.
Problem. So in the previous paragraphs, essentially, there were multiple properties discussed between the parties, between Ms. Cook and the complainant. She sent her multiple different options, and so I'm going to bump down to the property at issue in this case. On or about October 14th of 2024, Ms. Cook had resent some photographs of available property that she identified as 2007 Bluff Villas in St. Helena Island in South Carolina, which is referred to therefore throughout as 2007 Bluff Villas. A lot of the properties were on that same, I guess in that same complex. I think this was, villas. So a lot of the addresses that were discussed are Bluff Villas Road. But in the agreement, I have tried to make sure that I put in what specific addresses were for each one. But the one really at issue is 2007 Bluff Villas. The complainant did respond to Ms. Cook that she wanted to rent that 2007 Bluff Villas for the dates of April 11th through May the 10th of 2025. On or about October 29th of 2024, respondent represented herself as the property manager for that property and sent the complainant a rental lease agreement for 2007 Bluff Villas for the dates requested for a rental price of $11,414.66. Ms. Cook instructed the complainant to mail her a check in the amount of $5,707.33 made payable to essentially her brokerage, and to mail it to her attention. She said that the remaining balance of the same amount was due in January 31st of 2025. At that time, when she sent the property management agreement, she also provided the complainant with the check in and out times and told her to contact her a few days prior to arrival for final check-in instructions. She also told the complainant that any cancellation would result in the forfeiture of her deposit and any payments due. Before signing the lease agreement that the respondent had sent to the complainant or remitting any money to her for that 2007 Bluff Villas property, the complainant learned that Tide Watch Vacations was actually managing that property. The complainant spoke to Tide Watch Vacations and learned that the respondent had rented the 2007 Bluff Villas with them in the complainant's name, using the respondent's address, telephone number, credit card, and had created an email address with the complainant's name at Yahoo that the complainant did not agree to and had not created. Tide Watch informed the complainant that the total rental price for the property was $5,741.15, not the over $11,000 that had been quoted to the complainant by the respondent. So as a result of learning that information, the complainant filed a complaint on November the 8th of 2024. A notice of complaint was sent by the commission investigator to the respondent to make her aware of the allegations. And on June the 27th of 2025, the respondent provided a written response and supporting documentation that was requested. In that, she denied representing herself as the property manager for 2007 Bluff Villas. However, she admitted that she did facilitate the rental of another Verbo property that was listed under another rental company online, which was that 2007 Bluff Villas Road's address. She stated that she made the reservation using the complainant's name, but her own contact information in an attempt to provide complainant with, quote, higher level concierge services. Further, she admitted to creating an email with the complainant's name, which she said was to keep all of the pertinent details regarding the transaction clear and organized for her records. So she is agreeing that that these actions are a violation of 4057 710A2, and that she made a substantial misrepresentation involving a real estate transaction, and 4057 710A5, and that in the practice of real estate, she demonstrated bad faith, dishonesty, untrustworthiness, or incompetency in a manner as to endanger the public. All the exhibits are attached to the memorandum of agreement that support the state's case. And it's my understanding from Ms. Cook that she has a statement that she would like to read to the commission, as well as an exhibit, which I believe has been marked as Respondents Exhibit 1, that she's made copies for the commission of. The state has no objection to her passing that up or hearing her statement. So I would turn to Ms. Cook at this time for her mitigation and clarification.
Cook, would you proceed to pass out the information that you'd like for the commission?
I believe that Ms. Brown has that for you.
Cook, would you like to proceed?
Yes, thank you. Good morning, Commission members. My name is Heidi Roy of Cook. In my initial response to Ms. Silsby's complaint, I did not initially provide all of the details that I'm going to present today. The complaint that I initially received did not contain all of the exhibits and information that were later provided by the Commission months later. This is the first time I have ever encountered a formal complaint being filed against me in my 24 years of working as a property manager in charge and running my own business. Contrary to the facts stated within the Memorandum of Agreement and Stipulation of Fact, there was no real estate transaction that ever took place between myself and the complainant. My dealings with the complainant never endangered her or the public in any way. My dealings with the complainant were never malicious, calculated, or misleading. I would like to now take this opportunity to explain the events that led up to this hearing with you today. I communicated with the complainant numerous times over a 5-month period by email and by phone to discuss 3 different rental properties that I manage, not just one as asserted by the Memorandum of Agreement and Stipulation of Fact. All 3 properties initially offered to the complainant were properties that I manage for the owners. Number 4 of the Memorandum of Agreement and Stipulation of Fact incorrectly states that the complainant initially contacted me about a property that I manage at 2015 Bluff Villa Road. However, the correct address for the property was 2006 Bluff Villa Road. There were listings for both of these properties on VRBO, and Ms. Silsby initially inquired about the first listing, 2006 Bluff Villa Road, which is listing 906215 on VRBO's website. This was the first of 4 different properties that the complainant inquired about over an extended period of 5 months, including one that was listed with another rental company. In complainant's complaint, the complainant insinuated that I was somehow doing something questionable by suggesting contact with her outside of the VRBO booking platform. The complainant made multiple requests to provide her with information for other available listings that I managed. However, the sharing of information on other listings and direct communication with guests are both strictly prohibited by VRBO's communication rules and guidelines until after a reservation has already been made on their website to ensure payment of their booking fees. They also block the address and contact information from guests until a reservation has been made. Eventually, the complainant revealed that she was on LinkedIn and provided me with her private email address so I could contact her directly. When guests inquire about renting for a month or longer, I also prefer to have direct communication rather than communicating through an online booking site. Direct communication with guests inquiring about longer monthly rentals allows me to offer other options that may be difficult to find online, as online booking sites only show properties that are available for set dates without any flexibility, and often show properties that are not even located in the location the guest is looking for. Guests also often get frustrated because they are not familiar with the site and find it difficult to navigate to find available properties when search results come back with over 50 different options to look through without consideration of the guest's unique requirements. Also, the online calendars of these platforms are only indicative of reservations that are made through their reservation system and do not always provide a comprehensive look at all reservations that are made through other means of reflective of dates blocked by an owner for their own use. Direct communication with a guest allows me to offer similar options that may be available for the same time a guest is looking to stay, in the event a property is unavailable based on the search parameters provided by the guest. After receiving the complainant's request for information through VRBO, I spoke with the owner of 2006 Bluff Villa Road to check their willingness to rent during the time the complainant had requested to stay. I subsequently emailed the complainant to let her know that the owners of the property had decided to come and stay at their own property during the time that she had requested to stay. I mentioned that I had another similar property that was available but received no immediate response from her expressing any interest. The complainant's next communication with me was a month later, again through VRBO, when she emailed me asking for pricing for the alternate property that I had mentioned to her the month before. I sent her pricing but didn't hear anything from her again for another 2 weeks when she emailed me another request asking for photos of the property. I sent her a link to the VRBO listing for the other property that I managed at 2017 Bluff Villa Road, along with the pricing for the new dates that the complainant had requested. 10 days later, she emailed me to let me know that she was unable to open the link, so I spoke with the complainant by phone. During our conversation, the complainant asked if there were any other properties that I knew of on Data Island that were available, as she wanted to be aware of all of her options. I checked to see if any other neighboring properties were available and found that another agency had an available property at 2007 Bluff Villa Road that was listed on their website. Following our call, unbeknownst to the complainant, I placed a hold for the property online by paying a deposit. To be clear, no agreement was ever signed with the other company since I never received a rental commitment from the complainant. Because 3 months had already passed since the complainant initially inquired about renting on the island and availability was becoming scarce, I had placed the hold on the company's website to ensure the property would be available in the event the complainant should decide to proceed with her reservation. Placing a hold under the complainant's name should not have been an issue, as numerous clients, such as real estate agents, outside businesses, etc., regularly place reservations for other guests using their credit card as payment. Placing a hold on the property was done to serve the complainant in a concierge role and in no way harmed the complainant, as the hold was made with my own credit card as a courtesy in the event that she did decide to proceed with a reservation. None of the complainant's personal information was ever provided to me. I created an email with the complainant's name to keep the details of the hold in a separate online file for future reference should the complainant decide to proceed in making her reservation. Another month passed. The complainant contacted me again by email saying that she was still interested in renting a property on Data, but that her dates had changed once again. At that time, the property that was listed by the other company was still showing the original dates as being on hold, as well as the new dates that the complainant had requested as available. I provided her with this information and didn't hear back from her again for another month. Without any prior notice from the complainant, a month later, I received an instant booking that she had made through VRBO for a property that I managed at 2015 Bluff Villa Road. I figured that she had decided to book the reservation through VRBO to avoid the stricter cancellation policy that we had previously discussed for reservations made through me directly. The complainant had expressed her aversion to my cancellation policy in prior emails. VRBO's cancellation policy is much more lenient, allowing guests to cancel their reservation up to 60 days prior to a guest's arrival and receive a full refund. This makes it much more difficult to re-rent a property for an extended period of time by another guest, especially when seeking to secure another longer monthly rental so close to the beginning of the rental term, resulting in a potential large loss of income to the owner. This is why I try to advertise on VRBO just for shorter weekly and daily rentals instead of monthly rentals. We try to encourage the shorter-term rentals through the VRBO listing because there's just too many criteria that factor into longer-term monthly stays. I explained to the complainant that the owner of 2015 Bluffalo Road, which is the address that she had made the reservation on VRBO for, was unable to honor her reservation as they were planning to stay at their own property during the time that she wished to rent. The amount that she paid to VRBO through their instant booking system was over $4,000 more than any other reservation I had previously quoted in direct communications with the complainant for any other rental properties that I managed. She unsuccessfully tried to force acceptance of her VRBO reservation by stating that she received a confirmation from VRBO and insisted that there should be no way of canceling the reservation since it had already been confirmed. I contacted VRBO and they subsequently canceled her reservation and provided her with a full refund due to the owners not having the property available since they were going to be staying there themselves. She expressed her indignation that she was unable to stay at 2015 Bluffalo Road after VRBO canceled her reservation. Another month later, the complainant sent me an email stating, and I quote, "With the understanding that there are no other rentals available from 4/5 to 5/10 other than 2007, which is only available from 4/11 to 5/10, I would like to rent 2007 from 4/11 to 5/10. This was done 3 months after I had placed the hold with the rental company that 3 months prior. So it was an considerable amount of time had passed. After receiving the complainant's email, I did not immediately respond as I had become weary of her lack of commitment and indecisiveness to secure a rental after months of corresponding with her and spending hours writing messages back and forth. I considered not responding to her email, but after further prompting from her to send her an agreement so that she can confirm her reservation, I sent her my standard boilerplate rental agreement, not even thinking about the fact that the agreement stated that I was the property manager for the property that was being rented. I was more than ready for her to reach a decision after 5 months of frustrating non-committal conversations and complete indifference to the time that I had spent to accommodate her multiple requests and demands. She had all of the information. It was clearly time for her to make a decision, even if that meant she chose not to move forward with renting a property that was offered through me. My hope was for her to make a final decision, either commit to a rental or discontinue communications with me and rent elsewhere. Again, I feel it is important to repeat, using an agreement that I listed myself as the property manager for 2007 Bluffalo Road was never done with malicious intent. I used a boilerplate agreement that I've used numerous times in the course of business, without considering the fact that I was listed as the property manager of the property that was being rented. It was a clear oversight and mistake on my part that I deeply regret. However, a transaction never transpired with the complainant to rent any property through me at any time. So there was no harm done to the complainant or the general public as asserted within the memorandum of agreement and statement of fact. I never attempted to coerce the complainant into making an agreement to rent any of the properties that were offered to her for rent. The decision was clearly hers alone to make. As you're all aware, pricing of real estate, including rentals, changes based on timing, length of a guest stay, market conditions, and supply and demand. All of these factors were considered when providing pricing for the various rentals that the complainant and I discussed throughout the 5-month period in question. After receiving the memorandum of agreement and stipulation of fact, I did online research to see if I could find any more information on the complainant. To my surprise, when doing a search online under the complainant's name, a biography immediately came up on Wikipedia, stating that the complainant served as the United States Attorney for the state of Maine for 7 years, was a law clerk to a court justice at the Maine Superior Court, and has served as a professor of law at an Ivy League university. It is intimidating to realize that I was negotiating with such a highly accomplished attorney with years of education and expert legal experience. I certainly do not wish to spend money on expensive litigation to hire an attorney to defend myself against the complainant's punitive complaint based on her own misunderstanding of the events that occurred, when I am simply trying to do the job that I've been hired to do by my clients as a property manager in charge doing business over the past 24 years. It does not feel like a fair playing field. Furthermore, 4 months ago, this past October, almost a full year after the complainant filed her initial complaint with the Real Estate Commission, a brand-new instant online booking was made by the complainant through VRBO for one of the very same properties that I manage on Dawtaw that she had inquired about last year prior to filing her complaint. I declined the reservation with VRBO and asked them to cancel based on a clear conflict of interest. The exhibit that I provided is the copy of the reservation that she made this past October. I did not speak with the complainant about this reservation. I just contacted VRBO directly and told them that there was a legal issue that was still pending, and I felt there was a conflict of interest. So they canceled the reservation on my behalf. But the way that their system works, in order for me not to be penalized, they had to cancel it on her dashboard so that it shows up as a cancellation that she made. So I actually made the cancellation, and I do have additional documentation if you need to see the email that the VRBO correspondent that I spoke with sent to me after I canceled it. Complainant's most recent attempt to make another reservation online through VRBO causes me to pause and question her intentions. In my opinion, the complainant's latest actions are bold when this action that she initiated against me has not even been fully resolved. To try and secure a rental through a back door by going through VRBO again after filing this complaint borders on intimidation and harassment, challenging me to see how I will react. It feels as though her complaint was made in an effort to simply make a point and attempt to injure my professional reputation because of her own unrealistic expectations. I also want to make the Commission aware that when I received my property management license, VRBO and Airbnb did not even exist, so there was no training to deal with a situation like this. I signed the Memorandum of Agreement and Stipulation of Fact to bring a conclusion to this matter and do not wish to invest any more time or resources into arguing this matter with the complainant. Having any complaint filed against me has profound effects that I take very seriously. Knowing all of this, I ask that the Commission take all of these facts into consideration when making their final decision.
Look, I have a question for you. For the purpose of this Real Estate Commission, obviously, VRBO is vacation rentals by owner. Share with the Commission your basic model with your company. How do you work with VRBO? Are you working directly with the owner? Who is your client? Who do you represent, et cetera? Would you share that information with the Commission, please?
Of course. The VRBO listings that I have for the properties that I have listed through VRBO are all of my listings with VRBO. So I'm basically the administrator for all of those accounts. The owner doesn't have any. Basically, those accounts are mine, not the owner's. So any kind of correspondence that comes through those VRBO listings, I respond to, and I take care of all matters related to renting the property to individual renters.
Is your agreement with the owners of those properties?
Yes.
You have a listing agreement with them?
I do, yes.
To perform property management with them?
That's correct.
And then
And to advertise through VRBO.
You in turn have an agreement with VRBO to post those properties on VRBO? Is that correct?
I have an agreement with the owner to advertise the properties for them so that I can rent their properties and gain income on their behalf. I pay any income that I receive through any rentals that I handle. Those all come to me, and then I disperse those payments out on a monthly basis. And the owners instruct me whether they want to be whether they want their property to be advertised on VRBO or not. And all of the owners that I work with do advertise with both Airbnb and VRBO.
Not being familiar with the agreement between you as a licensee and VRBO, can you put in simple terms what that agreement entails?
Basically, anything that pertains to the rental of their property, they give me full authority to handle on their behalf. The only thing that the owners are really involved in is just providing me with their banking information or their address so that I can send them their monthly check based on the reservations that I receive for their properties.
This time, Commissioners, questions for Ms. Cook, please.
Before you canceled the second reservation she made, did you ask your client if your client wanted that canceled?
I did.
And what did your client?
You're talking about the VRBO reservation, correct? Yes. They actually, the owner had already at that point informed me that they were going to be staying at their own property for the month of March. The calendar on the VRBO listing didn't update with the owner's usage dates because it was basically that I hadn't even had an opportunity. When I got the reservation from Ms. Silsby, the complainant, he had not informed me that he was going to be coming down to stay.
Testified through your reading of your letter that the reason you canceled it is because you thought she was being vindictive and trying to set you up. But now you're saying that the reason you canceled it is because the homeowner wanted to live in to use the property, not. Which one is it?
Wait, can you repeat your question, just to make sure I
When you
understand?
read your what you wrote, when
Right.
you read your statement, you said that Mrs. Silsby, whatever her name is, that when she booked this second booking, you felt it was manipulative and vindictive, and she was trying to set you up, and so you canceled it because of a conflict of interest. You said, in fact, you contacted VRBO and told VRBO it was a conflict of interest. I now asked you, did you talk to your client before you called VRBO and told them it was a conflict of interest? And you said, my client actually wasn't going to rent the property for March. That's two different responses. Which one was it? Was it the fact your client wasn't going to rent the property for March, or were you calling because it was conflict of interest?
I initially asked my client, my owner, whether they wanted to accept the reservation, and they said that they were unable to, due to the fact that they were going to be coming down and staying at the property themselves, and they were unable to change their reservations.
Well, why would you call VRBO and tell them it's a big conflict of interest? It's just said it instead of saying the property's not available because my client's going to be actually there instead.
VRBO has very strict cancellation policies. They penalize you if you are the owner or the host canceling the reservation. To be completely honest, I didn't feel comfortable considering the circumstances with this whole complaint. I've never spoken to Ms. Silsby following the complaint, and I haven't had any correspondence with her. I just felt that it wouldn't be in my best interest as the property manager managing the property, as well as the owner's best interest, because I don't know what she's going to do when she's staying at the property as a response to, the issues that we've had with this complaint. She proved to be a very difficult.
Well, my problem is it sounds either you're being dishonest with VRBO or now being dishonest with us. Because if you're telling VRBO that you canceled because of the conflict of interest, but the reality of it was you're canceling because of the seller, the owner of the property, wanting to use their own property, and there would be some type of cancellation fee or some penalty, and so now you're going to VRBO, making it as a conflict of interest issue when that wasn't why you were canceling. So that's either being dishonest to them or you're being dishonest with us.
No, I actually did not cancel. When I called VRBO, I explained to them that there was a conflict of interest because of, first of all, I was surprised by the fact that Ms. Silsby was making another reservation, considering all of the things that had led up to this complaint. That was first off. So the fact that this was still an unresolved issue, there's where the conflict of interest lied, because she's placing a reservation. If she's questioning my integrity as a property manager and me, doing some kind of wrongdoing with her, my question was, why would she be wanting to rent the same property from me a year later? She had all of my contact information. She could have reached out to me and said, you know what, I'd like to rent this property, and we could have had a conversation. But this was all done online. There was nothing, there was no messages sent to me prior to receiving the instant booking. I didn't have the ability to even, the way that VRBO is set up, you can either review the details of a reservation before it's booked, or to rank higher on the ranking metrics where they see your properties up higher on the search list. You can accept instant bookings for the property. There's times when people will instant book a property, and after speaking with the owner, you find out the owner's going to be staying at the property themselves. So I wasn't lying to the VRBO. I was basically saying that there was a conflict of interest. And there was also the fact that the owners were coming down to stay. Both of those things were true.
The first listing, at any time did Ms. Silsby understand, or did you make sure she understood that you were acting on her behalf to try to find her another property of which you were not the property manager? And if so, did you ever explain to her that there would be some type of upcharge or fee that she would have to pay? Because when she contacted you, she clearly, from what we see from her statement, she thought that you had the actual listings yourself, and that was the fee. But now what we're seeing is she contacted you, you put her into a completely unrelated property to which she contacted you on, and then upcharged her almost double for that. Is there any time that she understood that she was going to be upcharged? As a real estate broker and property manager in charge, do you feel like you have a duty to notify her of how you're going to be compensated in that transaction? I mean, quite frankly, she could have just gone to VRBO and booked it herself and not paid you $4,000 more.
I guess the question is, if she's making a reservation for close to $14,000, which is $4,000 more than I ever quoted her for any of the properties, one of the quotes that I provided her was the quote that I provided her for the property that was listed through the other property, through the other property company. Sorry, I lost my train of thought. The amount that she was willing to pay through the VRBO listing, that she signed up for that reservation, where she agreed to rent from me a property that I afterward found out the owner was not going to be able to rent to her. She was willing to pay $15,000, close to $15,000 for that rental. The amount that I quoted her for renting the property that was listed and available through the other company was substantially less than that. It was $11,000. So
Actually, $5,000.
Correct.
It wasn't $11,000, it was $5,000, and she'd have gone straight through that company.
but she didn't.
Right, but did you tell her that by not going directly through that company and going through you, that you were going to upcharge her?
I didn't realize that I needed to do that. I mean, companies, if you go through Expedia, let's say if you
Did
go
she
and buy
even,
a...
my problem with this, and I'm not trying to be argumentative with you, is that, did she even know, did you even take an effort to explain to her, a modicum of effort, what you were doing? Because when I call VRBO, I feel like I'm dealing with a person who actually is that listing. At no point would I think that somebody else who is unrelated to that listing is going to put me in another listing, in a listing I could get for $5,000 and charge me 11.
That wasn't a conversation that she and I ever had.
Problem.
And that's why I can see why this lady's highly ticked off.
Mr. Chairman. Commissioner Burnett. Mr. Pickering, let me go back, and Ms. Cook. I think there was a little confusion on the booking that we were talking about, the 13,000. It happened twice. That's probably the confusion. If I'm reading it correctly, during all of your original conversations going back and forth with her, there was, and she wanted 215, you had told her it wasn't available, and then at some point, VRBO said it was available if she hit the instant booking button, which she did. That was the $13,900 whatever dollar amount, or whatever it was. And you then said, you contacted the owners. They said, no, shouldn't, we want to have the property during that time. You canceled that booking. Then you had further discussions with her that led to the next property, which we're going to talk about in a minute. But then, after all that was resolved, in September or October of last year, she hit the instant booking again for the same property, the 215 property, and that's the one you said by your statement that it was a conflict of interest, and I immediately canceled it on VRBO. And that's where Commissioner Pickering, I think, was trying to say, you made that decision to cancel it. You did not contact your owner at that point, per your statement, and ask them, did you want me to cancel this because I'm in a conflict with this lady? You just said, I'm in conflict, I think she's trying to trick me somehow, I'm going to cancel this thing immediately. That was your statement.
I did contact the owner to see whether they wanted to accept a reservation for the month of March, and they advised me that they were going to be staying at their own property for that time period.
That was your statement for the first one, but that's not what you read us in the second one. I wish you'd been a little clearer about that. But irregardless, we'll go on with that assumption that you've got.
I did contact the owners to let them know that there was a booking that was made through VRBO for the month of March, and they told me that they were going to be staying at their own property for that time.
Jump ahead a little bit to what Commissioner Pickering was also touching on, which was you have signed agreements with all of your landlords.
Correct.
Management agreements. And in those agreements, are there specified management fees that you receive?
Yes.
Real estate transactions and real estate law in South Carolina, you have to be specific. You have to have a written agreement on what you're going to receive in fees, whether it be a sale of a property or leasing a property. Same for buyers, same for sellers. If I receive a fee from a buyer purchasing a house, I have to have a written agreement specifying if they're going to be paying me, who's paying me. What Commissioner Pickering's getting to is what you actually did in this transaction is you charged a tenant over $4,000 in a fee for you to negotiate finding them a property. And even to the point where in your own testimony, you said you thought she was a bit of a waste of time. She had contacted you, she went back and forth, she'd never make a decision. You took that property off the market for that other owner for 3 months.
Correct.
You put a reservation on that by your own testimony, you said, I thought she's wasting my time, she wouldn't make a decision, she went back and forth and wishy-washy here and there, but yet you took this other owner, who is a member of the public, who we're here to protect, and their property was off the market for 3 months. They couldn't rent it to anybody else because you put a deposit on it and just held it all that time, even though you couldn't negotiate anything with her at that point. So that gives me tremendous pause. I'll stop there. But that's I guess you need to understand, you're out there, we're here to protect the public and to make sure that the license law is being followed. And some of your misunderstanding of license law is giving me great pause. And I'll
Yep. So I'm just curious, the justification between what the other company had it listed, what it would have cost this person to stay there was $5,741, and you quoted $11,414.
The amount was not the same that they charged for me to make the reservation is what they charged her.
Explain that, what?
The amount that they quoted her to book that property for that time period.
Yeah.
Keep in mind that when I put the hold on the reservation, it was more than what she paid for it 3 months later. Pricing changes depending on when somebody makes.
Well, the material that I have collected by the state, it says very specifically, Tidewater informed the complainant the total rent price for that property was $5,741, and you quoted her $11,414.
I don't remember what they asked me to make a payment for. I know it was different.
Well, Tidewater says $5,700.
That was her quote. My quote was not the same. The amount that
So they're charging you more?
Yes.
45%, by the way, that's
45% more?
45%
That's
commission rate
not
you
real.
basically charged her. So from 5,700 to 11,400 is 45% commission you charged without getting anything in writing.
Do you have any documentation, as it has to be as per our statute, where this client agreed to pay that much and that much more?
No. There was no agreements that were made between myself and the complainant at any point.
And do you see a conflict, as he pointed out, of tying up somebody's property for 3 months on a maybe you get paid? Do you see that as a
I
conflict?
never signed an agreement to rent the property, though.
But was it still not tied up? You said you reserved it. Is that correct?
I made a deposit, but
What does the deposit do?
it doesn't, it holds the property for a certain amount of time.
Sure does.
That wasn't,
Exactly. So
but it wasn't 3 months.
you-
Said 3 months in what you just wrote, you read to us.
I checked, I didn't have any correspondence with, because I hadn't heard from Ms. Silsby, the complainant, for, for a long period of time. She made the reservation, I put the hold on the property, and then when, I hadn't heard back from her, I didn't have any further correspondence with the other company that managed the other property. So, I didn't know how long they were going to hold the property just based on a deposit being made, because normally when I rent a property, I send an agreement, and if the agreement isn't signed, I follow up with the individual that has rented the property and say, do you still want this property, because I haven't received anything in writing stating that you have agreed to actually rent this property. And when I went back and looked at my bank statement, there was no charge, there was no deposit that was charged to my credit card. So I'm not sure what happened from the other company's point of view, because I didn't have any further correspondence with them.
Ask a clarifying question real quick. Well, really two. Do you have a copy of the MOA in front of you with the attachments?
I do.
Can you please turn to page 67?
Don't have the attachments. Let me get that.
Yeah, the numbers are in the bottom center of each page.
Okay.
So I'm just asking to follow up on Commissioner Lee's question. This page 67, appears to be essentially a receipt from Tidewatch Vacations saying that the total cost for the rental of that other company's property is the $5,741.15. Are you testifying here today that they actually charged you something different than the $5,741.15 that's on this receipt?
I'm going to have to look at my receipt again, because it's been so long since all of this took place, but I believe so.
Well, look at it, because it has your client's name, your address, and your fictitious email attached to said receipt.
I'm not sure if this is the reservation that Ms. Silsby made on her own behalf. That's what it,
So
That's-
why would she make a reservation on her behalf using your physical address and the fake email address? Why would she do that?
that could have been a typo from the
There's a lot of
other com-
typos. A
the other
complete wrong
companies.
address and a fictitious email account she knows nothing about.
No, I thought that this reservation that was listed here is the reservation that she made for herself.
Are we looking at the same thing?
Yes.
67.
That's what I thought she provided, was a copy of the amount that she paid for her reservation. It was $57.41.15, and this is a receipt of what she was sent by the company.
Okay. And is that not your address at the top?
Yes, but I didn't place that there. That's something that the other company would have put there.
So the other company, you realize how none of this is tying together well, right? So you're telling me that the other company with her name, your address, and the email that you made up, how do you think she got the address? I mean, this receipt, did they email it to the fake email account and you sent it to her?
No, this was the receipt I understood that this was a receipt that they sent her after she made the payment for her reservation on her own.
Again, how did they get it to her? If all of the contact information here is wrong, how did she get this piece of paper?
I don't know, because I wasn't
the system,
involved. I
Andy.
can't speak to what I,
It may have already been in the system if she had already tried to book it once herself with that information, so they may have pulled
And
it
if
up.
that's the case, how did the complainant get this to us? How did she get her hands on it if they don't have the right address, nor do they have the right email address?
in her response, she said that that was the receipt for how much she paid for it.
Just to clarify, if you look at page 15, this is the complainant statement. This is the receipt, which is Exhibit 11 to the complainant statement. She says that that's how she found out that it had been secured by the respondent, and that's how she found out that there was the respondent's address, respondent's email address that was made up, and so I believe that the complainant has set forth that that was how she was able to determine that Ms. Cook had taken out the reservation with Tidewater.
So Tidewater was going to charge you more than they charged her to facilitate the stay, is your testimony?
I have to look back because I didn't have that information. I didn't realize that we were going to go through having an evidentiary hearing today, because I was ready to go ahead and sign the memorandum of fact. And
So I think that 5,000 whatever amount reservation was sent from Tidewater to the complainant to show what had been sent to the respondent.
Right.
Correct.
And you have no idea what they were going to charge you? Because you did state that it was more than what they charged her.
I think so. So now I'm looking here and it says, so she rented the property, and I guess it's my misunderstanding because it does say that she said she rented the property for $7,501. So
I would just like to ask one more clarifying question, just because I don't know how Verbo works on the property management or owner side of things. Is there a way in Verbo when your owners tell you, hey, I'm going to go to my property from this date to this date, is there a way in Verbo to block those dates off and make it unavailable?
there is. VRBO only tracks reservations that are made through their website.
But you can still block off time?
Yes.
If you know that the property's unavailable during a set period of time? Okay, thank you.
That leads to a question I guess I had, because I'm not totally familiar with it. But I think that to move up in the rankings, the appearance of your property showing, you needed to do the instant booking, that helped you move up. So you put instant booking on properties that you did not have knowledge whether the owner was going to let you rent it instantly or not. That's kind of because it happened twice.
Yes.
What you're saying.
When a reservation comes through, especially for a longer monthly reservation like that, I try to express to my owners how important it is to let me know that they're going to be staying at their own property further in advance, because people can make reservations. She was looking at making a reservation. Initially, her inquiry was back from May. She was looking to come back and stay almost a year later. So owners aren't always aware of the fact that they're going to be making plans, or, it's a long period of time before the reservation is scheduled to come in. So in many instances, the owners won't let me know. Like, I just had one of the properties that we're speaking about, for instance, I had a monthly rental for, not the one that Ms. Silsby rented, but another one that they rented for the month of March, and they made their reservation just, I want to say maybe 3 months ago. And when I contacted them, I I contacted the owners, said we've got a reservation, and I always just inform them, okay, these are the reservations that we have coming into your property, and let them know the amount of money that we can expect to receive for that reservation. He contacted me back and said, oh, no, I need to be there for the month of March. And he insisted that he couldn't honor that reservation. So I can't honor a reservation that the owner's going to be staying at their own property. It's unfortunate. I hate having that situation come up, but it's something that the owners do from time to time, especially during that period of time, because I guess they just don't take the reservation as seriously. They think it's their property, and if they want to stay at their own property, they disregard the fact that the property has been rented through VRBO. They just don't understand the gravity of making a reservation and having their property listed on VRBO with the instant booking status.
I guess that's what I was leading up to, is really the instant booking status is something you determine whether you're going to do or not because of the algorithm. And if you know you have properties like that, why would you do it? I mean, why would you put in an instant booking when you know you're going to have to turn around and ask an owner if they can rental or not?
In many situations, I can find another available property that will work, because they're all basically all located in the same general vicinity, same floor plan and everything. So I'll try to see if I have another alternative that they can rent, similar to what I did with Ms. Silsby.
But you understand the perception with the public is, if it says instant booking, it means I have it. It's like buy it now on eBay. It means I got it. I'm going to pay this high price, I got it. And the same thing with instant booking, but you're using it just as a way to increase the view of the property. Maybe this is commonplace. I don't deal with VRBO, but it seems somewhat misleading to the public.
I have a clarifying question or two. I believe we're talking about, or confident we're talking about two different events. As it relates to, putting a property on hold, when it's on hold, the deposit's made, can somebody else rent those weeks on VRBO if you put a property on hold?
Without an agreement, they don't have a legal agreement that I'm renting the property. There's just a deposit that has been made. If I'm making a reservation and I don't have a legal agreement stating that the renter has agreed to rent the property, I have a certain amount of time that the hold will be put on there, and I will assume that reservation is going to move forward. But traditionally, with my reservations, if something like that comes through and I haven't received a signed rental agreement or confirmation through an online booking platform, then I'll follow up with that individual and say, I haven't received your rental agreement. Do you still want to proceed with this reservation? So
if I'm on there, I find one of your properties and I want to put a certain number of weeks on hold and I provide a deposit, those weeks continue to show up where someone else could rent it?
yes, until I get a rental agreement.
It's not removed from opportunity for other members of the public?
That's correct.
Okay. And in relation to, thank you for clarifying that, in relationship to the 2026 rental and cancellation, earlier I wasn't clear. That is different than when the owners were in there for March, which was, I believe, the subsequent.
Correct.
Because the dates on this are March 28th through May 9th. And your answer earlier to that, I wasn't clear on, did you consult with your property owners?
Yes.
Before
Yes.
addressing the conflict of interest and the cancellation?
Yes.
Thank you.
Question, another question about how Verbo works. If somebody has booked through the instant booking, and then you contact your owners and they say, no, we're going to use the property during that time. If that is the explanation you give to Verbo for that, what happens as far as going ahead and canceling that booking? What is sort of the blowback on the owners normally?
The VRBO has a policy that they try to, if in the event that a property is not going to be available for a guest that has made an instant booking, they tell us as a host to contact the guest and have them cancel the reservation on their own, so that it's not going to be penalized against our ranking metrics as a host, and it won't affect our listing and our visibility on the website. So in the event that
But if the owner did do it, if you didn't contact the person directly and you just clicked whatever button on your side to say, nope, host declines, what?
they will stop your listing from being, I believe, because I've never done that before. I can't really state what they would do, but normally what I do is I contact, if we do have a conflict where the dates aren't going to work for whatever reason, I contact the guest and explain that there's a conflict, and ask them if they would be willing to cancel the reservation from their end. And if they, and then I'll propose other options of other properties that might be available for them. But I first approach the guest to see whether they're willing to cancel the reservation from their end.
Right, but that's not what I'm asking. I'm asking, let's just say they say, no, absolutely not. I did instant booking, this is mine. If you can't meet that agreement, you need to cancel on your side. Do you know what happens when you cancel?
I really haven't had that situation come up before. The renters have, or the guests have agreed to cancel their reservation, and we just mutually both agreed to cancel their refund, or cancel the reservation and provide them with a full refund.
Other questions? Commissioner.
Still would like to know how you got to the $11,414 number.
If the fair market value for the property, because I had 3 other reservations that I had already sent her. She went ahead and booked a reservation that was over $13,000 at one of the properties that I wasn't, so subtracting the VRBO fees, because she wouldn't have been booking through VRBO, I gave her a rate based on, again, pricing changes. Pricing changes depending on when somebody is booking a property. So what
So she paid $5,700, and you're saying she would have saved money by paying you $11,000?
When did I say that she would save money?
You said that she was going to pay over $15,000, when in fact she was paying $5,700.
No, the booking that she made at 2015 through VRBO, the instant book,
Okay.
was over $13,000. And she tried to push the acceptance of that reservation with VRBO. And really willing to pay $13,000, over $13,000 for her stay.
But
All right, let me ask it to you this way. If she would have booked through you for the 11,000 figure, how would that money have been dispersed? Who would have gotten that money? Give me a quick ledger sheet. 5,700 go to the property owner? I mean, who got what if she would have paid you that?
Well, that reservation wouldn't have been handled through, are you talking about the VRBO reservation that she made for my property owner? Or are you talking about?
The stipulation of facts say she booked it for 5,700, but you had quoted her a price of over 11,000.
Okay, that property wasn't one.
Same for the same property.
Right, but that wasn't a property that I manage. So I would have collected those fees and paid for the reservation that I made through Tidewatch. Similar to like Expedia making a flight reservation, you're not making a reservation directly through the flight agency, you're making it through Expedia.
All right, you're going to have to dumb it down for me. 11,000 hits the table, where does the money go?
It's received, and then the monies are paid to the other company.
Give me the breakdown. Who gets what dollar amount? That's all, that's what I'm asking.
I would have received that money as compensation for the time that I had spent to accommodate that reservation.
How much of that money? How much of the total amount collected from the renter would you have received?
The difference between what the company, the other rental company owed, or was owed for the rental of the unit, and what I paid.
Which is pretty much double what it cost. So, and understand, to receive that money, you'd had to have a written agreement where she acknowledges that that she gets paid that amount. I struggle to believe anybody out there, especially an accomplished attorney, is going to willingly agree to pay double what something costs.
I can't speak to what she would have done. She did do it because she paid $13,000 for a reservation that I had the listing for. She was clearly willing to spend that money because
What
she paid
she's
that.
willing to spend?
She did pay it. It's not just willing to. She paid for her reservation. $13,000 was paid to VRBO for that reservation.
Well, in this time period, it would have cost her $5,700, and you were charging her $11,000.
Again, she paid, nobody twisted her arm to rent the property on the instant booking through VRBO for $13,000.
But just to clarify, that was a separate property than the 2007 Bluff Villa Road.
Right.
That she was willing to pay that amount for was a completely different property.
Right.
I have one question. So had the respondent rented this property, upon her checkout, she would have received a receipt? And how would that receipt been itemized?
Checkout?
Yes.
I don't issue a receipt at checkout.
So there's no folio that shows how much you paid for the rent?
You sign the rental agreement and provide the deposits, and then you get the signed agreement back stating that the rental is executed. That's basically it.
It just has house, $11,000 on the receipt. It doesn't have a breakdown of.
No, on the rental agreement, it just has the amount that is being charged for the total rental. And, we're both agreeing that she's renting the property for that amount, and that's the amount that's being paid.
You would have received that from your company or from VRBO?
From me, because she was renting through me.
Mr. Chair, I'd make a motion to go into executive session to seek some legal advice, please.
Closing statements first. All right, let's do closing statements first. Cook, would you have any closing statement? You have a closing statement for the commission.
I thank you for your time today, and I apologize if I made a miscalculation on the way that this was handled. I definitely will not do this in the future. VRBO and Airbnb, I work with them on reservations a lot, and they basically handle reservations exactly the same way that I did. That's why I got the impression that it was okay to do this reservation, because VRBO upcharges what I will charge for a property versus as a property manager, as a host. They upcharge all reservations that come through, and they get booking fees. So I thought that it was okay to go ahead and charge more for it as a booking fee, because I had had 5 months of going back and forth, and I would be coordinating everything and working as her point of contact and concierge for the rental. And I guess, I just want to make it clear that there wasn't any malice that was intended with this at all. It's something that other companies, I booked a plane ticket with Expedia and just was curious and went to look at the airline's website. I wasn't meaning to demean your intelligence by any means by bringing that example up, but I looked after the fact to see how much they were charging for my plane ticket if I had gone directly through the airline, and they charged significantly less than what I was charged through Expedia. I did spend a lot of time with her. She asked me for, it wasn't like I just came up with this idea to rent another company's property to her. She asked me, she kept on, all of her correspondence was, I want to know all of the properties that are available. Tell me all of the options that are available. I would think, I'd send her pricing, and then a month would go by. And then she'd say, well, I want photos of that property, so I'd send her photos. Then she'd ask me, do you have anything else? She'd go back, or she'd inquire about another VRBO listing, and I'd respond back to her and say, after talking to the owner, this one's not going to be available. This one's available. And then she wasn't able to access the links that I would send her with photos on VRBO, because I was trying to encourage her to rent other properties that I had, and all of the prices that I had quoted her up to that point were less than $10,000 prior to her making the reservation on VRBO for over 13. So, you know, I guess that's, you know, basically what I just want to say other companies do, you know, do that. They upcharge for handling of the reservation, and I'm available to the guests from check-in to check-out if there's anything that they need during their stay. I also serve as a concierge for all of the reservations that I make. And I guess for my own edification for the future, I would like to be able to find out from the commission, is there an acceptable way of doing this? Because, again, you know, I've had other instances where other companies have charged, you know, based on making a reservation or making a reservation for another company that they have authority to make reservations for them, find out that they're charging more than, you know, the company that I'm actually booking through. So I just didn't realize that it was an issue, because it's commonplace in the marketplace, so I didn't think that it was an issue. And I didn't realize that it was going to be different for a real estate transaction.
Counselor?
Yes, just
closing statement.
briefly. I think some of the issues here are that Ms. Cook did not have a property management agreement with the owner of 2007 Bluff Villas Road. So she didn't have the authority to send the rental agreement, setting herself out as the property manager for that address, to the complainant in this case. And she also, I guess, contacted Verbo and set up all this information, giving the complainant's information, but her contact information and an email address that was created under the complainant's name without having a rental agreement signed by the complainant or having the complainant's permission to even make a hold on that property. It wasn't clear that the complainant was going to go through with that listing, I guess, or that rental. I think that Ms. Cook has said that this went back and forth for multiple times, but I think that the issue here is that she didn't have the authority to do these things. She didn't have the permission to do these things. And I know that she was saying that there wasn't a real estate transaction because the rental agreement wasn't signed, but the only reason the rental agreement wasn't signed is because the complainant found out from Tidewater that she could get the property at half the cost from them. And so then she felt deceived, which I can understand that as a member of the public, she wasn't told by Ms. Cook, that's not my property. Tidewater is actually the person helping, you know, the person that's the property management company. You can either go directly through them, or I can serve as your concierge service. I don't think that that disclosure was made, and I think that the complainant's statement makes it clear that she had no idea that this was not her property, and until she contacted Tidewater and was given all that information. So I think the issue here is that she was doing things she didn't have the authority to do. She was setting herself out as a property manager for a listing that she didn't have, and she didn't have authority from that owner through a property management agreement to do it. And then she didn't inform the complainant about the upcharge or tell her, this isn't my property and you can get it at a much discounted rate if you go straight through them. So I do think that this was a situation where, you know, this is a danger to the public. The public was duped, the complainant, and I'm glad that she was able to find out that she was able to book it straight through them at half the cost. But I don't think it's clear that just because she was willing to pay $13,000 for one property doesn't mean that she's willing to pay the amount when she could pay, $5,000 for a different property. So I don't think that that argument really holds water. But I do think that, I know this was a memorandum of agreement, but I feel like there's been a little bit of argument as to whether or not the statutes were met, and so I wanted to make sure that I made that clear for the record. And I do think that the state has proven by preponderance of the evidence the two statutes that we have set forth in the memorandum of agreement, and I would just leave it in your opinion as to what, if any, sanctions that you deem are appropriate in this case.
Thank you. This MOA and the additional information presented today is submitted. Is there a motion to go into executive session for legal advice in this matter, or is there a motion as to the disposition?
I'll make a motion to go into executive session.
I'll second.
We have a motion and a second to go into executive session for legal advice where no votes will be taken. All in favor of the motion, let it be known by saying aye.
Aye.
Have a second?
Second.
All in favor of the motion, let it be known by saying aye.
Aye.
Is there a motion as to the disposition of this case?
Yes, I'd like to make a motion, Mr. Chairman. My motion will be that we accept the MOA as presented, that the state has in fact proved the violation of 40-57-710A2, as well as the violation of 40-57-710A5. My motion would be that there's multiple problems with this case and your handling of this particular matter, of which I'm not going to address them all. And the reason I'm not is that I find the main violation to be extremely egregious. If you take VRBO or Airbnb out of this, it comes down to this. A consumer contacts you, you show them properties that are not your listings, which you do not have a listing agreement on, and you have no representation agreement of that buyer consumer. So you're showing properties that you have no listing on, and you're representing or purporting to represent a buyer without any representation agreement, whether it's a client agreement or a transaction brokerage agreement. And then to compound matters, you then pay yourself a fee, which appears to be about 100% fee, with, again, no agreement from the consumer for that fee. So because of that, I find that the state did, or I'd like to make a motion that we find that the state did prove all the facts, and that we indefinitely suspend you until the completion of the property manager course, the property manager in charge course, and that you complete both of those courses and you pass the exit exam. I'd also make the motion that we fine you $75 per violation for a total of
You said $75.
$7,500 per violation for a total of $15,000. So your indefinite suspension would go until both courses have been completed and passed and the payment of the $15,000. Any
Ask one
clarifications?
clarifying question. Did you also want public reprimand?
And a public
on this?
reprimand, that always is part of the, yes.
Thank you.
You've heard the motion. Do I have a second to the motion?
Second.
By the way, 120 days to, well, no, she can pay it whenever she wants. She just can't practice again until she does. So there's no dates on that for payment. I'm sorry.
A change to your motion. Do we have a second on the motion?
Second.
All right. Is there any discussion of the motion? Not all in favor, let it be known by saying aye.
Aye.
Ms. Cook, the decision we announced today expresses only the basic elements of our ruling in this case. Advice counsel will prepare a document which more fully expresses our conclusions in the appropriate language and the format which the commission traditionally uses. The final written order will be approved and signed by me, the chair. If you wish to appeal this order, you must appeal it to the Administrative Law Court within 30 days from receipt of this order. You'll be receiving information from the commission. That's the final ruling. Thank you. Good to move forward. All right, this hearing is called to order. This is a disciplinary hearing in the matter of Christopher Brand, case number 2024728. Do any commission members need to recuse themselves from hearing this matter? The hearing is being held in accordance with the provisions of the South Carolina Administrative Procedures Act and the statutes and regulations of the South Carolina Real Estate Commission. My name is John Reinhardt, and I'm Chair of the South Carolina Real Estate Commission. The attorney assigned to advise us during the hearing is Brandy Duncan, Advice Counsel with LLR. Shannon Davis, Disciplinary Counsel with LLR, will represent the state. Were the pleadings furnished to each member of the commission? Ms. Wade?
Yes.
And Mr. Chair, this was initially scheduled as a formal complaint hearing, but yesterday, the parties and I were able to come to an agreement on a stipulation of facts, which has been, I passed out a copy to everybody, and I would ask at this time to make States Exhibit 1 the notice of the formal complaint hearing, and then States Exhibit 2 the stipulation of facts that has been supplied to all the parties as well as the commission members.
Thank you, Counselor. Hearing will be conducted as informally as compatible with the equitable presentation by both sides of the case and in compliance with the provisions of the Administrative Procedures Act, the Commission statutes and regulations. Brand, are you represented by counsel? Yes, sir. Counselor, please give us your full name and address for the record, please.
Thank you, Mr. Chair. My name is Cheryl Shaun, Shaun, and I'm here also with my colleague Max Mazurik. We're with the firm of Maynard Nexon, which is at 205 King Street, Charleston, 29401. And that's Suite 400. Sorry, I left that out.
Brent, do you receive the notice of this hearing that was sent out? Yes, sir. My understanding, the parties have entered into a stipulation of fact. Is this correct?
Yes, sir. Sorry, I was getting him a microphone, Chair.
That is correct. Further, it's my understanding that the parties have agreed to the facts and the stipulations, but respondent does not admit that his actions have violated the statutory provisions alleged by the state. Is this correct?
Yes, sir, it is.
Sir.
Disciplinary counsel will present the stipulations of fact, and the respondent will be allowed to address the commission thereafter. Counselor.
Thank you, Mr. Chair. Again, we are here in the matter of Christopher S. Brand. His real estate license number is REL 3907. He is a broker in charge, and this is case number 2024-728. Mr. Brand is licensed by the Real Estate Commission as a broker in charge and was so licensed at all times relevant to this matter. He first became licensed by the commission on October the 26th of 2001. The respondent is located in Boca Raton, Florida, and supervises the following agent group realty brokerages. The first is Agent Group Realty, which is REO 18949. Agent Group Realty Columbia, which is REO 27165. Agent Group Realty Greenville, REO 27169. Agent Group Realty Myrtle Beach, REO 27166. Agent Group Realty Referral, REO 21465. And Agent Group Realty Charleston, REO 27172. Respondent has no prior disciplinary history with the commission.
Before we continue, I'd like to have the respondent and any other witnesses sworn in, please.
Oh, yes, sir, I'm sorry.
Absolutely.
Thank you. Please proceed, Counselor.
Thank you. With regards to the allegations of the complaint in this case, on or about July 7th of 2024, broker Joel Barber, on behalf of AGR Brokerage, and while under respondent supervision, entered into a listing agreement with the homeowner for property located at 601 37th Avenue in North Myrtle Beach, South Carolina. The term for that listing agreement was from July 7th of 2004 until October 12th of 2024. I'm sorry, I think I said that wrong. July 7th of 24 until October 12th of 24. On or about August 18th of 24, the homeowner requested that Mr. Barber remove her listing from the MLS because she had disagreements with the listing agreement that had been provided to her from the broker. The homeowner alleged that the terms that were set forth in the listing agreement that she received were not those discussed between the homeowner and Mr. Barber. However, Mr. Barber refused the homeowner's request to remove the listing from the MLS unless completed under certain conditions. On or about August 20th of 24, at approximately 9:31 a.m., the homeowner sent a text to respondent as the broker in charge, asking that he call her at his convenience, preferably that day. On the same day, at about 7:18 p.m., the homeowner sent another text indicating that she saw that the respondent was ignoring her concerns, her voicemail, and her text message indicating that she will file a complaint as a result. However, respondent did not answer, and homeowner left a voicemail requesting a return call. Respondent never contacted homeowner regarding their issue with Mr. Barber. After the first text message at 9:31, respondent received a copy of an email from Mr. Barber to the homeowner and consequently was aware there was ongoing communication between Mr. Barber and the homeowner. On or about August the 22nd of 2024, a complaint was filed with LLR alleging professional misconduct on the part of Mr. Brand. However, Mr. Brand did not become aware of that until he received the notice of complaint in November 4th of 2024. According to Mr. Brand, he did have a conversation with Mr. Barber on August the 23rd, 2024 about this issue. Thereafter, on August the 26th of 24, the respondent was copied on an email correspondence between the homeowner and Mr. Barber, wherein the homeowner set forth certain demands to be met by August the 30th of 24, to which Mr. Barber responded, but the respondent did not respond. On or about November 4th of 24, the Commission's investigator did send the notice of complaint to respondent, setting forth the allegations made against him and requesting written response. The respondent did respond on or about December 16th and December 18th, and his responses are attached to the stipulation of facts as Exhibit 16. He provided, and he did attach supporting documentation regarding this issue. He did state in his response that as the broker in charge, he delegated the duty of speaking to the client to a licensed supervisee with a lot of real estate experience. I would defer to Mr. Brand and his counsel with regard to the mitigation and impairments. I'll let them hit those. But the state is alleging that as a result of this conduct, that Mr. Brand is in violation of South Carolina Code 40-57-710A21, in that he violated a provision of the chapter or regulation of the Practice Act, specifically those being 40-57-135A1, in that he failed to adequately supervise employees or supervise licensees to ensure their compliance with the chapter, as well as Section 40-57-135A4, in that respondent was not available to the public during business hours to discuss or resolve complaints and disputes that arose during the course of real estate transactions in which the broker in charge or supervised licensee was involved. So that would be the allegations of the stipulation of fact. And again, I would turn to respondent's counsel with regard to mitigation and impairments, and would ask to address at closing at the appropriate time.
Counselor, would you like to address the commission?
Mr. Chair, and I'm sorry, I'm used to being, it's hard for me not to stand up. Mr. Chair and members of the commission, we can present the statement that has been prepared by Mr. Brand, or we can allow Mr. Brand to present the impairment statement.
Choose.
So nervous here. Never really been on a. How's that? Good afternoon. My name is Chris Brand, and I'm here before you today as a result of a complaint filed against me by a former client of my brokerage. First, I'd like to take this opportunity to apologize for any harm I may have caused the homeowner as a result of my actions or inactions. In my 25 years as a real estate professional, I have never had a situation like this arise with any one of my supervised licensees. But I'm here before you today to take responsibility for my shortcomings as a real estate professional and broker. As I stated in my initial response to Ms. Farmer, I'm happy to correct any behavior deemed to be deficient by this board in order to best serve my clients in the future. When I first hired broker JB, I believed he was a genuine individual and a hard worker. I believed him when he told me that he was being treated unfairly due to his attempt to enter the market from up north. Unfortunately, deceived me and most regrettably our clients. At the time these events unfolded, I believed everything was being handled by broker JB. Professional manner. Broker JB had his broker's license and 10-plus years of real estate experience. Nothing previously would have led me to believe he was handling in any way other than professionally. When homeowner first reached out to me, I was shortly thereafter copied on broker JB's correspondence to the homeowner, in which she provided her with options for terminating their agreement. A response that I believed would result in the resolution of the dispute. In retrospect, I now realize I should have followed up with her to personally address her concerns. I was supposed to act as the intermediary for her when a dispute rose between her and one of my agents. Though it does not change the events that took place, corrective measures have been taken following these events to ensure nothing like this ever happens again. My brokerage has since parted ways with broker JB, and a new policy has been instituted in which all inquiries or requests received by me personally are followed up on within 24 hours of its receipt. By adhering to this new policy, it will ensure an open line of communication with our current and prospective clients, as well as ensure that a miscommunication like this does not happen again. As it relates specifically to the homeowner, I genuinely believe that broker JB's response, with me copying on it, was a sufficient response to her attempts to contact me. Her text messages came in around the same time broker JB sent the email on which I was copied, and I did not hear from her in the days shortly thereafter. I certainly did not actively ignore her, nor would I ever actively ignore one of our clients. I honestly believe that by having both broker JB and I on the same email chain, that was sufficient response to her attempts to contact me. I also followed up with broker JB by the way of telephone call and spoke with him at length about the situation, to which he led me to believe her concerns were being addressed. I now know I should have followed up with the client separately to obtain both sides of the story, rather than just obtaining the information from broker JB. Unfortunately, at that time, I believed broker JB was someone I could trust and rely on, and believed him when he said he was handling her complaints. I would apologize for my shortcomings as it relates to this homeowner and take responsibility for the same. I will take any action this board believes is necessary to correct these wrongs and alleviate any possibility of something like this happening again. That's all I...
Thank you, Mr. Brand.
Sir.
Council, comments on behalf of your client?
Your Honor, just briefly, I had some comments prepared, but I think Ms. presenting the position to the commission. Is genuinely apologetic. And this occurred with this particular homeowner. Mr. Brand did not know what he did not know about this particular broker. Some months, some significant number of months later, gather more information. He contacted counsel. With the assistance and advice of counsel, he did separate from this individual. And now, standing here before you, asking you if you find that punishment, consequences are necessary, that please they be minimal. Regrets this, he sees the error, wants to do this right. He's done it for a long time, and he wants for you, if you find consequences are essential.
Counselor. This time, the state, if they would like to make comments first.
I would defer to the commission as to whether or not they have questions for the respondent, and then I'd be happy to make final comments.
Questions to the state or to the respondent?
I've got a couple. You've got a lot of offices here. I can't say. You've got a lot of offices here. How many people do you supervise?
About 160. It's just more for compliance. It makes it easier to have multiple offices.
Sorry?
It's about 160. They could all be in one office. It just makes compliance a little bit easier with the Realtor board.
Them all spread out all over the state?
These days, we just work through a dot loop and the telephone. I mean, that would be... Yeah, I mean, it looks good in Zillow, if I'm being perfectly honest. Always honest. That's a wrong expression, but yeah.
If it looks good in Zillow, what?
If I change chairs with him so he can.
That'd be awesome, yes. I didn't understand what you said.
All I was really saying is about 160 agents in total, but I actually don't see where the supervisory part of it's really changes a whole lot from like 2 offices to 1 office to 17 offices. We more or less do that for compliance, not really supervisory type stuff.
So you live in Florida?
Yeah, I'm in Florida. I went down there a few years, so I hope to get back up this way over the summer. But yeah, it was a good school down there for my son with autism, so I tried out Florida, learned a lot, ready to come back home.
I like Florida myself. Are you licensed in Florida also?
Yeah, I don't do very much here, but I do hold a license. I bought my own house down there. Yeah.
Okay. All right, so one of my concerns anyway, I'll say this, I am concerned when I know I manage significantly less than that, and it's a handful, so I struggle to see how you can adequately supervise 160 people across the entire state of South Carolina properly, number one. 2 is I'm concerned about your understanding of basic real estate law. I mean, in your statement, you said that you assigned the responsibility. Where does it go? Said, considering a broker in charge is allowed to delegate any of the agents underneath him, and it is clear she had spoken to my agent. Is this really necessary? It very specifically in our statute says you are not allowed to assign your responsibilities as broker in charge.
I made a mistake. I understand now. It's a tough year with all the new rules.
And that ain't new, man. So that's been around literally since real estate and brokers in charges have been.
I made a mistake.
It was in the 11 law, it was in the 17 law, it was in this past law. It's basic real estate, right? And the whole point, and I heard your statement, and I appreciate what you said because you're not wrong. The whole point of you being readily available to the public is to settle things like this, right? Is so that if there is a conflict with one of your people, the broker in charge thing is a checks and balances system is what it's supposed to be, right? So you're not just supposed to be available, you're not supposed to just to be available to the public, but also to your people, right? You should know what's going on those contracts, on those listing agreements. You should know what was going on in them, and you don't, right? So you look at every listing agreement, every buyer agency agreement, every contract that comes across 160 agents, you check them all out, make sure they're good.
I spent a lot of time reviewing the files. It's not a perfect system, sometimes, but recently we have a system called Dot Loop, and I said, you have to do this stuff. Now, listen, there's always going to be an elderly person or somebody that wants the pen and paper, and that can't start in Dot Loop. They have to print it from Dot Loop, right? Yep. But I told them under absolutely no circumstance. Well, actually, I told them they just had to do it in Dot Loop. I know I'm going to get the call where, somebody wants to do pen and paper once in a while. But what I'm telling them now, and look, I spent a lot of time investing in the software. Like researching. It's not just buying it. You got to know what to buy, right? With most of the population, you should be able to do it electronically, and if they do it through our system the way they're supposed to, I'm always going to have access to it, and there's systems in place to where they submit when it's ready, but I do just read through before they're submitted. I try to. It's definitely not like going through filing cabinets, it's a much quicker and simpler system. It's,
Sure.
It's some people don't like them, and I'm like, still, I don't know. But we've built customized forms, and we have templates. It's spent a lot of time on it, and it's a lot of work. I hope to, but I feel like, I was having I guess I was having a bad day that day. I don't know. All I can do is apologize and tell you how I messed up.
Brent, a question for you.
Yes, sir. Yes, sir.
Tell me what a typical schedule is for you for a week.
I wake up, I wake up at 7 o'clock, I go to the gym, I try to be in front of a computer, where it's an actual office or kitchen countertop. But I try to be in from a computer, pretty much 9 to 5, unless I got a dentist appointment or something. And, I work a lot of Sundays, in the evenings, trying to get bookkeeping and stuff set up. Lately, I'm outsourcing a lot of administrative stuff. I just see the need. I never minded working like 78 hours a week, but probably I should, I probably should be working 70, 80 hours a week in a different capacity. But I'm making a lot of progress. This might be hard for a lot of people to see, but believe it or not, the technology does a lot more than the actual human beings. I love human beings. I'm a human being, I have children, and so on. Work with me, and and anytime something I hear about it, it's about the people I work with, and but the technology, you need both. You need people and administrative, and you need technology. But the technology is doing what 3 people can do, and it's something I've been working on for, in some ways for 25 years.
I hear you say you basically supervised by technology.
Technology that definitely streamlines, and as far as it goes, I'm sure there's real estate brokers in South Carolina that have a lot more than 160 agents. They're now doing it. I feel like I'm doing a pretty good job. I've had some bad days, and it's not an excuse. I'm not going to let it happen again. It's just not going to happen again. I'm just kind of hit me that I need to really just wake up, and I definitely understand that I made a mistake.
When's the last time you visited each of your offices? How often are you there?
Really, if
you're under oath.
I don't know if I've been to any of them recently. I have all the mail forwarded. But, you know, the offices are really, again, well, as far as having a different address as opposed to 6 or 8 or whatever it is, offices in exactly the same address, I mean, it's just Versillo. I mean, none of my agents come to the offices either, you know, because why would they? We have an office in the virtual world that they can access from their cell phone or their tablets, you know, like, if they were in the office, they'd just be on a cell phone or they'd be at their tablet here doing a contract on the cell phone talking to me if I was right over there. You know, they're probably texting me as the room was crowded, because sometimes it's easier to text than talk if your kids are there, right? I mean, nothing would really change if we were all in the same room, you know, that's just how, I mean, from what I see, it's mostly how real estate's being done was most of the time, you know, except for when someone, you know, there's certain people that would prefer to do pen and paper, which, regardless of your setup, you go to somebody's house to do a listing agreement, you can't instantly see that pen and paper, but if they do it in dot loop and someone's at somebody's house doing the listing agreement, I can see that. I mean, I might not know to look at that particular moment, but if they tell me they're doing it, I could be out in California and watching them write that agreement.
If your house is listed with your company, one of the companies that you are broker in charge, and I come to your office and ask to meet with you personally,
I'll get there somehow if it's important to somebody. Nobody's ever asked.
you've never had a client come to your office and ask to meet with you?
I mean, it's been a lot of years ago. Not in the last 10 years. And if they did, they would give them my phone number. They could call me. I could talk to them. And yeah, I would come there if it was important to somebody. Absolutely. I just don't know why that would be important to somebody these days. But I mean,
Well, it's important to us because it's in the statute.
I can do it. Yeah. Look, I'm eventually coming back to South Carolina. This is just home.
So
Honestly.
Mr. Brand, I think some of the problem too is and you seem like a nice enough guy, don't get me wrong. We've seen worse, I promise. But you're missing some of the concept of basic real estate, right? So personally, I can tell you now, as far as adequately supervising, what that also says is you can actually guide your agents through particular scenarios. I used this earlier today. So like Lake Huey, for example, I'm from upstate South Carolina.
Yeah, Lake Huey, yeah.
So we had two lots, right? They were listed with a company out of Greenville. Thank God they didn't sell, because when we got them listed, we told the guy, he's like, you need to sell this one first because this pier zone on this one will make this one undockable. So instead of worth $550, it's worth $150. So we get paid for our knowledge base of a particular area, a particular product, right? The way real estate, traditionally speaking, the way the law was written, everything is based on that the broker in charge actually knows the area. My position is you can't properly supervise the entire state of South Carolina and be an authority or know it like you should know it in order to properly advise the new agent coming in behind you. So if you have, for example, if you did have something on Kiwi listed and you had that situation with a new agent, you wouldn't know it and the agent wouldn't know it. So that member of the public just lost $400,000 because you didn't know what you were talking about. You lacked the knowledge base. So understand my concern. Just like doctors, for example. Everybody in South Carolina that's a doctor is licensed as a doctor. But you don't go to a foot surgeon if you have a brain tumor, right?
Of course, yeah.
So my concern is you're supposed to be who they can go to, they can look to for knowledge and of a specific area, a town, whatever it may be. You don't have that because you can't, and I can't do that. God knows I couldn't do that. I'm not suggesting I could, but you can't be an expert over the entire state. This is my concern when it comes to proper supervision. That's part of it.
Help you here? I want to help you with some questions, if I may, Mr. Brand. I want to help you.
Yes, sir.
So,
Yeah.
are you available by telephone to your real estate agents, the ones that you supervise?
Yeah, they're all the
And do you
numbers.
take regular telephone calls from them when they have questions?
Yeah, we do Zoom meetings and all sorts of stuff, and I meet them in person. I was at Lake Huey a couple weeks ago, as a matter of fact.
Okay, and do you have meetings with them regularly online or some other type of format?
Yeah, I mean, yeah. I would send a lot of emails and I ask for questions and sometimes sometimes I just do videos and send them to them, like kind of just me doing the meeting and, be in touch,
Right.
You know how to be in touch,
So if you have a policy or procedure or something that you've seen that one agent has violated in one part of the state, you might send a video to everybody saying, don't do this?
Yes, sir, yeah.
All right, and if I worked under you and I had a problem with my client, I could call you and get advice on how to handle my client?
Oh, yeah, of course, yeah,
Could my
sure.
client call you? I know in this situation you didn't call him back, but could my client call you?
Yeah, and believe me, lately, I mean, half my calls are like somebody that's trying to rob me, like somebody on Guam or something, and I'm calling them all back, because I don't know, maybe it is a
Right.
client, it's like crazy. Oh, I have something personal to talk to you about, like, I don't know who that is, but you know what, I'm calling them anyways. I mean, it's,
And you have Zoom, in case I wanted to have a Zoom meeting with you, we could have a Zoom meeting.
well, technically I do Google Meet, but yeah,
Okay,
it's
Google Meet.
essentially the same thing, yeah.
I mean,
I don't know why I like Google Meet.
my
I'm
colleagues
weird.
and I have a disagreement on this. Our statute's very clear that you can supervise the whole state. You have a state license. I'm sorry that the statute doesn't match what everybody wants, but that's what our statute says. I don't know that are you aware of any limitations that would eliminate you, or not allow you to supervise somebody in Charleston at the same time as in Spartanburg? I'm not aware of any statutes. I'm sorry. I know that's not what y'all want to hear, but that's what the law says.
Yeah, aware of any, and I know it's
And we don't have a geographical location.
common throughout the United States what I do.
He's not incorrect. We don't have a geographical location.
We're attacking him because he has 168 agents. I know brokerages that have 300 agents. They have them. We have brokerages like EXP that their entire platform is online.
Yeah.
Being available to the public, there's nothing in the statute that says you have to be physically available. It says you have to be available. He's available by phone call. He's available by Zoom.
Yes, sir.
I'm sorry, but it seems like we're taking our personal opinions about what supervision is out on him today.
So, no, I'm not at all.
I would disagree that we were, with my colleague here, that we're attacking. I think there's elements to this that are generally misunderstood in terms of expectations of compliance. Our duty is to protect the public, members of the public. To an extent, there is variation in scope and interpretation, but there's material elements to the things we review on a material basis. And I agree wholeheartedly with Mr. Lee that, having an element of knowledge, even to just purely the paperwork compliance, which I'm familiar with the numerous technology systems, as well as AI integration to help me. I've more agents, I believe, than Mr. Lee, or around 50, 60 licensees in total. But, the challenge of, even with just reviewing documents and things like that, is the element of local knowledge. We are protecting consumers, things like transfer fees, things like various setbacks, flood, things on a regular basis. We're training agents on. You're looking at, you're encountering, but the concern, one of the concerns that I think you understand now is the delegation of your role. Right? It sounded, initially when you were presenting, and we were referencing, there was a reference to JB, that it sounded more of a character concern versus the actual delegation of the role. Right? But the delegation of the role is the biggest issue.
I understand now that I shouldn't do that. It was just a lapse of, it was just a bad day for me that day. I don't know why I didn't respond to her, honestly. It somehow worked out in my head that day. It was okay. Probably any other day I would have called her back. For what it's worth, I could say, I don't go to real estate schools and stuff hiring people. Most of my people have been in business 3, 4, 5, 10 years, like some a lot longer. I mean, I work for my agents. I know a fair amount about like Kiwi for my agents that work up that way, I don't live there. It's very nice. I may live there one day. But look, if I live there, I'm not going to live in Charleston, but I spent my whole life in Charleston. You know what I mean? I went to school in Myrtle Beach, most of my friends went to school in Columbia. It's not like I'm completely, these are like foreign places, you know what I'm saying, that I've never seen. Some of my best people are around Seneca, I saw you at a round table there a couple weeks ago with Robert Whiteside,
Oh, really?
Yeah. Yeah, I'm getting around. It's not like I mean, am I an expert? I mean, if I was an you know,
I have a
I mean,
que-
nobody can know everything. I mean, but, you know, I do read a lot. The real estate market, South Carolina, I get a lot of South Carolina emails, this, that, the other, and I mean.
Commissioner Mitchell has a question for you,
You,
please.
Mr. Chair, I have a question regarding, I heard you mention that you have seasoned agents, I will use the word, but what is how do you provide for your newer agents? Do you have, I heard you talk about Zoom and also Google Docs, whatever you call it, not Docs, but Google Meet, but let me ask you this. How do you determine the needs of your clients, not clients, your agents, in terms of what do they need? If you're not supervising them in a way that you see what they're doing, you know what they're doing out there on the field, do you have knowledge of all of your agents here in terms of if they need you, or is it always a phone call? Do they reach out, or do you have something like, okay, I need to see you all every Tuesday at 10? Do you have something that they know that they're expecting from you every week, that they can say, okay, I know I have to be here, or I have to be someplace for my broker in charge? I mean, what do you do with them?
I mean, I don't have any strict requirements like that. I mean, I could if it was necessary. But as far as like new agents, I mean, it's unusual that a new agent new to the industry has any idea who I even am or even heard of the brokerage. On a rare occasion they do find this, I generally able to like talk them out of it, you know, like this might not be the right for you. But rarely if I do bring someone on, I mean, I find myself spending a lot of time on
You
it.
interview your agents?
Yes. Yeah, I mean, and if they tell me they're brand new to real estate, I mean, it's a little bit different than being, if they're coming from a different state or something, you know, and newly licensed to me. But yeah, and if they're new, I generally can talk them out of it without just saying no. But on rare occasion, when they make the right impression, I mean, I do spend a lot of time with them, but I can't take with so many. You know, obviously, it's, I have 160 people. But yeah, usually I'll take one or two a year, but they're getting one-on-one help, you know? I can't, or, you know, and I'm recommending, you know, people in the area that could, you know, maybe show them, you know, things in person or whatever, and I'm telling them, you know, the way I was taught many years ago, you know, like find subdivisions, do previews of the houses, you know, you gotta learn this stuff, you gotta take contract classes, you gotta, what are your questions? Like, and, you know, I mean, sometimes I'll talk for hours with them, but you look, I'm only bringing 2 or 3 people like that on a year, maybe, you know, like my business model, I would go broke.
Okay, your business model does not allow you to do that. You just want seasoned agents.
Yeah, I mean, yeah, I mean, I don't have a strict, I mean, probably I should, but like, but typically, just new agents just don't want to be with me. They want to be with DXP and Keller Williams. It's more fun. I mean, there's more like, you know, they got stuff for them, you know, and listen, most of those, them never even making the business, I want the people that, you know, the 5 years has passed, you know, they're probably going to stay in the business, but it's been tough these last few years. I mean, the real estate market's been, you
So
know.
do you know when your agents are up for their license renewal, all the seasoned ones?
Well, yeah, I mean, it's either 6:30 this year or next year. It's this.
I mean, I said, do you know who they are?
Yeah, I got it in a spreadsheet, yeah, I mean, what I save time, honestly, is just I send an email to all of them, and like, look, it's either this year or next year, make sure you renew, and, yeah, I mean, and I just kind of keep pushing. But it's coming about that time, probably April, you know, it's start, like, kind of blowing them up. I need to work on a CRM where I can text them. I used to like to text them, but that software became like, you know, everybody thinks you're spamming someone when it's really your own database. But that's something on my schedule to do. I've used very successfully in the past. And I'm considering making them sign something that says they have to read my emails. I mean, you would think anybody would, and if there's
In your
Listen, if there's
statement,
problems with people, I haven't hesitated to get people, tell people to go. Actually, I had an ethics complaint filed against me one time with the Realtor Board because I fired an agent. I just didn't want to be liable for him. I just didn't think that we communicated properly.
one other question. You mentioned in your statement that you had, that you implemented some new procedures since this happened. What is it? Can you
Well, it's just-
specifically say what it is?
Basically, I get a phone call, I'm going to respond within 24 hours. I mean, in the statute says that you take calls during normal business hours. I mean, believe me, generally speaking, I'm taking calls on Sunday, Saturday, like all sorts of time. I mean, last week, I'm talking to a lady in North Carolina at 9 o'clock at night. I know she's just, addressed her concern, and next thing you know, I heard about the kids in Tennessee and stuff. It's not like I'm shying away from it, and I never really have. I just had some I definitely had a bad day that one day. I justified in my head at the time that it was okay what I was doing, and when I look back on it, I feel just really stupid, frankly.
Tell us, because I know you said it's just primarily electronic, internet-based, in the cloud, whatever. How do you handle compliance? How do you make sure that when your agent, wherever they are, submits a new listing, submits a new contract, submits whatever, how do you keep up with compliance for your office?
That, can I make a motion, we go in executive session? I need 2 minutes to ask a legal question.
I've got two.
Well, I think, I understand that, but I think we need to go into legal advice to answer this question before we go any further. I think we're getting astray here, is what I'm getting at.
I'll second that motion.
Advice where no votes are taken.
Aye.
We have a motion. Do we have a second?
Second.
All in favor of the motion, let it be known by saying aye.
Aye.
Thank you. All right, we are at the point where we were in questions from the commissioners to the state. Any final question, or the respondent? We were asking questions of both when we went into executive session. Commissioners, do you have questions for either parties?
I have a question. Mr. Brand, have you, to your knowledge, received emails, text messages, phone calls in the past where a client may have alleged forgery or alteration to a document that was held between you and your firm and a client? Obviously, with the listing agreement being a contractual obligation, it'd be concerning, and it is concerning, and I think you've admitted that not returning a call or email or text message was not the right step in this, but given alleged forgery or alteration of a contractual obligation, in this case, it is concerning to me that you didn't reach back out. And I know it was a bad day, bad week and a half, whatever this span was. And I think you had mentioned in your opening statement that you weren't intentionally ignoring her, but that's the way it looks. When you don't respond to a text, you don't respond to a phone call, you don't respond to an email, and something that I can assure you would get my attention if someone alleged that someone under me had committed an act of fraud in a contractual agreement with my company that you're responsible for as a broker in charge. So that's my concern under this. I'm sorry, go ahead. Did you?
I reviewed that contract. I don't see any evidence of that. Now, I've learned a lot about Mr. Barber recently, and I wouldn't doubt today that he would do something like that, but just looking at the contract,
Yeah, well, I would agree. About looking at that, you probably wouldn't tell. But if you had taken the next step and followed up with the person who is alleging that had happened,
at that time,
then you would be able to understand what they are alleging, and you could dig deeper into that, right? You could say,
right, not making that phone call. At the time, I had so much faith in Mr. Barber, I would have thought that she was a crazy person, probably, but now I certainly want to think that, and now I certainly have a completely different perspective on the world. Because of that one man, I don't trust anybody anymore. Done. I don't know. I guess growing up in small town South Carolina, I was taught that you're supposed to give people they was never taught me you're supposed to give people the benefit of the doubt. I don't do that anymore. Nobody gets the benefit of the doubt.
well, I am not an attorney. There are other attorneys on here, but I would recommend never letting an agent speak on your behalf when lawsuits are alleged or that there is a threat of legal action. I'm sure your attorneys would say the same. So that's the time to speak up. That's the time to get in the middle of it. And as I think has been mentioned by several other commissioners, you certainly cannot delegate those duties to an agent. That is the broker in charge's responsibility. I think you've been licensed since 2001, is that correct?
2001, yeah.
How long have you been a broker in charge?
Most of the time, about 22 years.
Okay.
It's my 25th year. I think maybe October 26th or something, it'll be officially, done 25 years with a license. But yeah, shortly after 3 years, I became licensed. I think it was exception a month or so. I was at some friends. They started a Coldwell Banker many years ago, and they sold it off to a big company. But anyways, I was here maybe for a month or two. I don't remember, but I served.
Thank you.
Any other questions, commissioners?
Mr. Brent, whatever happens today, I would encourage you to spend some time with the license law and actually read it.
I'll read it some more.
Once again, I know this has already been said, but The license law does not permit a broker in charge to delegate the broker in charge responsibilities.
Yes, sir, I think I knew that, and I can't even explain what's going through my head. I don't.
Being a broker in charge myself, I understand those responsibilities, and they are burdensome. They can be very burdensome. As a broker in charge, you're going to get those calls on the weekend. You're going to get them at night. Life in the real estate business and has years. So I understand that. But the fact of the matter is, we have to follow what the law says. We did a document that came from the Real Estate Commission. If you have not been on our website for South Carolina, look up the information regarding the guidance document for broker in charge supervision. We've posted about 15 guidance documents, which I encourage all the licensees to go to that website and stay up to date on those guidance documents, because they involve, from the commission's standpoint, the protection of the public. From the licensee's standpoint, we are required and we are charged to regulate the real estate industry, which means we have to go back to the law and be specific as to what the law says. Any other questions from the commission to either party? Not, you have the stipulation of facts and closing statements, basically, is what I was asking. Thing that you want to say as a closing statement.
Go ahead.
I apologize for dropping the ball and making the industry look bad, and I promise it won't happen again. I'm just really embarrassed by the whole thing, and ask for your mercy.
I'll ask the state.
I may just briefly.
Sure, certainly.
It's been a long day.
Thank you, Councilor. Davis?
Because this is a stipulation of facts, I do believe that the state needs to prove by the preponderance of evidence the violations set forth. So just briefly, I think that the commission kind of gets this. You can't delegate broker in charge duties to the licensees that you're supervising. And in this case, there was an allegation from a client, essentially, that there was fraud in the listing agreement. And I think that's exactly what broker in charges are for, is when you have a client making these types of allegations, that you not only respond to the client when they try to reach out to you, but you also discuss it with your agent. And I know that Mr. Brand said that he reviewed the document and that nothing from reviewing the document gave him any pause. But if you'll look at page 5 in the Bay State materials, it's clear that the bottom paragraph seems to have 60, then 30 written over it, and nothing initialed next to it. And I know that real estate professionals are supposed to make sure that any changes made to the documents are initialed. And so I think that that would have given him additional pause to look into this situation even further. It's clear that the client reached out to him directly and made him aware of the situation. And I know that he said he delegated it to Mr. Barber because he was a licensed broker and he had been for some time. But I think when you're having an allegation from the public and a public member saying, you know, this is a fraudulent document, I think that it is your duty as a broker in charge not only to respond to the client, but to look into those allegations, even if you think that your agent is above board. I think that you have a duty to look into that, and that was not done in this case. So I do believe that the state has proven beyond a preponderance of the evidence both of the violations set forth. And I would leave it in your discretion as to what, if any, sanctions that you believe are appropriate in this manner. Thank you.
Counselor? Is there a motion from the commission as to the disposition of this case?
Sure, I'll make a motion. I believe the state has made its case in reference to 4057-135A1, 4057-135A4. My recommendation would be, or my motion, excuse me, would be Mr. Brand take the BIC class and pass the test, and a $2,500 fine per violation.
Have a motion. Do we have a second to the
Be
motion?
paid within 120 days. And the class within 6 months.
We have a motion on the floor. Do we have a second to the motion?
I'm sorry, before we get a second, you wanted the class taken within how much time?
6 months.
Wanted the fine paid within what time?
120 days.
Thank you.
Can you remind me, the motion fine, what is the amount? I'm sorry.
25 per violation.
Okay. And did you intend for there to be any type of reprimand?
You restate the motion, Commissioner Lee?
Yes, $2,500 fine per violation to take and pass the broker in charge class, and a public reprimand. And Mr. Brown, it's not, the class isn't punishment. I don't think you know it well, quite honestly. So we hear it all the time. When you hadn't seen it for 25 years, it's easy to maybe not be as fresh with it as you should be. So, punishment is that it's still you and your agents.
Yeah, I've been telling my agents, like, okay, we're required to do 10 hours, but I feel like I'm going to be doing a lot more this year, which I was kind of planning on doing more, I mean, it's been a lot of changes. I mean, it's like,
We have a motion on the floor. Do we have a second?
I'm sorry, Ness, that does not count as CE, so there's no confusion.
We have a motion and a second before we have discussion.
Second.
We have a second. Commissioner, now discussion. Commissioner Burke. Discussion on the motion. All in favor of the motion, let it be known by saying aye.
Aye.
Are there any opposed? If not, the decision we announced today expresses only the basic elements of our ruling in this case. Advice counsel will prepare a document which more fully expresses our conclusions in the appropriate language and the format which the commission traditionally uses. The written final order will be approved and signed by me, the chair. If the respondent wishes to appeal this order, they must appeal to the administrative law court within 30 days from receipt of the final order. This concludes the matter. Thank you. We're going to take a 5-minute personal comfort break before we move into old business.
let me take the whole, like, broker class, like, when I became a broker.
It's 6 months.
They said 60 days. I was like, is that impossible? Like, it's like-
No.
You have 6 months.
Oh, gosh.
At all.
No, it's been our pleasure.
Oh, we'll miss him. He won't be far. Gonna be working from home, so. Be up there. I think initially he's gonna be up for the first 6 months, and then maybe it's a day a week. paid for, nice resort. But we acquired the Lee and Associates office. I don't know what we're gonna, kind of looking at it. We're trying, right, we're trying to figure out, now that they're here. Oh, which, I don't know that one person really can, to be honest with you.
Colin, if you would. And item number 10 on our agenda is old business, limited service listing guidance documents. Commissioner Muskovich?
Yes, I hope you read the latest version. I love this document. Brandy made some edits. Why I like it, not just because it's educational for both the agents and potentially the members of the public. It's an incredible, reads almost like a case study on agency and the differential of a client and a customer relationship in a case scenario that's highly relevant. And I'd love to see this a part of future education, just the way it distinguishes certain things you can and can't do in real application. So thank you, Brandy, for all your efforts on it.
Agree with you. Thank you
How you
both.
really feel about it? Love it. Star review.
We have a motion in regard to this guidance document. I'll speak on behalf of it as well. It's excellent. Well done.
I enthusiastically second the motion.
Okay. All in favor, let it be known by saying aye.
Aye.
Opposed. All right, moving forward. New business, possible future statutes or regulations. Ms. Duncan?
Yes, sir. So there are a number of things kind of moving this year. First off, our regulations, which this commission had put extensive work into before the legislative session started, has received a favorable report from the Senate LCI subcommittee and is going to be heard by the Senate LCI full committee tomorrow. We have not heard any concerns or questions about it, so I am currently anticipating that they should be fine tomorrow. They have also already received a favorable report from the House Regs Committee. So they're kind of done on that side. So unless any last minute concerns come up, they look like they are probably set to go through just fine in May of this year. They, of course, would not, if they do time out in May, they would not become effective until they are actually published in the State Register at the end of May. And we would do some sort of a notification to our licensees to let them know that that document made it through, if it does in fact make it through. The other one I wanted to make sure to notify y'all about is a federal bill. It is S3502, and I believe we put a copy of the actual legislation in your materials for you. This one deals primarily with timeshares and what it would do if it passes at the federal level, and it's very early on. It's just been basically introduced at this point. But what it would do is require a clear single document disclosure of all costs related to that timeshare, including any ongoing costs such as maintenance fees. It would also require a 14-day cancellation period and transparent exit options, not necessarily dictating what kind of exit options the person has, but setting out clearly what those exit options are for that timeshare. This is not all that we already kind of have under South Carolina law, because we do already have a 5-day mandatory penalty-free period in South Carolina where people can get out of these. So you're talking about essentially a 9-day extension. And pretty much everything that's required to be disclosed are, under this bill, are essentially already required to be disclosed under South Carolina law. They're just not all done in one singular document necessarily right now. Enforcement mechanism for this would be through the Federal Trade Commission as a violation of the FTC Act. So if it goes through, impacts for the timeshare companies, and I'll keep an eye on it and let this commission know if it goes through. There are only two other bills on the state level that have had any movement really this legislative session that might impact anything directly involving this commission, meaning directly involving real estate. One is House Bill 3387, which deals with the ejectment of unlawful occupants of a residential dwelling. That one has crossed over from the House and has been residing in Senate Judiciary for several months now. The other one is House Bill 3569, which allows domestic violence victims to terminate a rental agreement prior to the normal time. That one has crossed over from the House and has received a favorable committee report from the Senate Judiciary and is just pending before the Senate. And again, if either one of those go through to completion, we will let you all know and get with staff to do some sort of an appropriate e-blast for our licensees to let them know.
Thank you.
Chair?
Yes.
I do have one thing to add to that. We talked about last week. I've been speaking with Jenny Nicely about the commercial course that she's developing. Talked to her multiple times. She's doing a great job trying to pull it all together. I would recommend, she's asking questions that quite honestly, either you or Alan need to, it's not my realm house. Maybe have a subcommittee put together. Alan could head that up if he's willing. Just to address some of the questions that she's having to make sure that she has what she's teaching in line with the views and the beliefs and understanding of law inside that course.
Idea, and I'd welcome the opportunity to work with Alan. Others? If not, we are open for public comments. Will, introduce yourself, please, to the
Yes, my name is Josh Bennett. I am a lawyer here in town at Rogers Townsend, also a licensed real estate broker. Most importantly, I run marketing for my wife's real estate team, and that's why I'm here today. Obviously, with a team, we are very cognizant of the changes that are coming about and coming into effect next year. And so as we're looking at that, even as a lawyer, when I look at the new team name changes, I'm not entirely sure if we need to change our name, but more importantly, what we can change our name to. So before we go and change a billboard and change out signs and everything else that comes with that, I thought it would be best to come and talk to you, see if I can get any guidance on that. So my wife is Sarah Bennett. She sells here in Columbia. And her current team name is Team Sarah, thank you, is Team Sarah at Better Homes and Gardens Real Estate Medley. It's a mouthful. So my question is, can we keep that same name? And if not, could we change it to Team Sarah, comma, Team at Better Homes and Gardens Real Estate Medley? When I look at the statute, I think it's a little bit ambiguous there because you have team name there in brackets, and then it follows with team at the brokerage is what the new law will be. I've spoken to my friend Nick back here, and he seems to think that we can do the second option for sure, the Team Sarah, comma, Team at Better Homes and Gardens Real Estate Medley. But again, before we go through the process of changing the logo out and everything else, I did want to come and see if there's any guidance that can be provided here. I appreciate your time today.
Mr. Chairman, if I could speak for just 1 minute.
Please.
Unfortunately, you're kind of asking the commission to give you legal advice about this statute. I would recommend, as we do for anybody who asks for legal advice from the commission when we can't really give it, that you follow the statute exactly as written. So if it says team name at whatever the brokerage name is, I would recommend that be how you do the name. Yes, sir.
In a general sense, instead of bringing Team Sarah name, I guess what the question was, can it be Team blank at brokerage, or does it have to be blank team at brokerage? Statute says blank team at brokerage, but was that really the intent? I think the intent was that we have team with my team name and then the brokerage. So the question really is team blank compliant with our statute, or is it blank team the only way you can be in compliance?
As they gave it in quotation marks in the statute, I would think it has to be exactly as it's written in the statute. If they had not used quotation marks, then perhaps there might be room for another interpretation, but that would be my understanding of how most courts might interpret that statute. Yes.
In a very specific, if you read it, it's very specific.
Okay, so then blank team at, but I can call my team anything I want to, so I literally could be team at. That's not the weeds, but I mean, I can call my team what I want, so team at Blair Cato is fine. I think that answers the question.
Possibly his question, possibly his second question is adding a comma. In other words, the second example he gave is exactly like the law states, except for it adds a comma. Is that comma going to throw it out?
So the right, the relevant part of the statute, in the new statute, the one that takes effect on May 15th of 2027, it is statute number 40-57360, and it's in subsection E, and it says, and I quote from the statute, team names must end in, quote, team name, team at, name of real estate brokerage firm, end quote, in the statute. So because in the statute they used the quotation marks, I think a reasonable court would interpret that as you have to do it exactly as written in that statute.
That help?
Sounds like you need a lawyer.
Yes.
And my wife needs a better one than me, I think. Yeah, I certainly appreciate that, and we will go and make a decision that equates to the statute and can definitely be in compliance. I will, just for the benefit of the group, I am still ambiguous as to, is it saying that you must have a team name, for example, that ends in team at Better Homes and Garden Real Estate Medley? Does it have to be the Sarah team at Better Homes and Gardens Real Estate Medley? Or is it saying Team Sarah, a team at Better Homes and Gardens Real Estate Medley, for example? I know I'm putting the A in there, but just for effect of what the comma would mean.
I've quoted the statute. I don't think there's anything more we can, statute says.
I appreciate it. I appreciate your time.
You're welcome. Thank you. Other comments? Welcome, Nick Kromitis, South Carolina Realtor, Chief Executive Officer. Welcome, Nick.
Commissioners, thank you for a few minutes of your time. I wanted to address a couple of things with y'all this afternoon. For the record, my name is Nick Kromitis with the South Carolina Association of Realtors. I'm the chief. It would be very helpful with this pending deadline on the implementation of the new team name statute that's coming into effect here in May. Y'all could consider a very short guidance letter with a couple of examples of what team name, of some compliant. If you remember the initial implementation of the team name language, I think it was in 2016 or 20, resulted in a number of teams having to go through an extraordinary expense to comply with the statute. And this would be very helpful if y'all were able to issue a short guide. That's not the subject I'd come to talk to you about. If I could switch gears for a second. And this has to do with process. And in those cases where the commission either revokes or terminates an individual's license, there currently isn't any active follow-up on the activities of those individuals who lose their license. And certainly in the case where you've gone that extra step and issued a cease and desist on top of the license revocation or termination, there isn't any follow-up done. And I'm going to ask that y'all consider amending your internal processes, some review in, maybe it's in the actual order that you issue in the termination of the license that calls for the investigative team to do a spot check 3 months or 6 months or 12 months from now. It's very easy to Google one of these individuals' names and to see if they are engaged in any real estate activity after they've lost their license. And would strongly encourage you, and it's 100% in pursuant of your mission of protecting the public, and it certainly would alleviate the phone calls I know that both of our legal departments receive in these matters. But if there's any process internally that can be adopted to allow that, and of course, if your council determines that there needs to be added either regulatory or legislative authority to do this, then we would love to be able to talk with you and support you in those efforts. But that was my main ask today, is to consider steps in following up after an individual's license has been revoked or terminated.
Thank you, Nick. D.
Our legal department has received numerous calls in the last 12.
Let me say this, as chair, I'm immediately in learning of telephone calls in regards to this particular situation. Both maybe have received calls. I've instructed advice counsel, staff, and investigation to stay involved in the investigation of this particular situation, so that immediately we have talked about and will issue cease and desist should that take place, should this person or any licensee continue to practice after a revocation of license. And I think that is probably what you're referring to. Am I correct?
No, sir. My request is more general in nature. It's not specific to the current process. When a licensee who has lost their license continues to practice, the staff react to complaints being filed. And the current process requires an additional complaint to be filed, even in the case where you have issued a cease and desist. And especially in those cases, and there aren't that many cease and desists that you've issued over the years, when a cease and desist is issued, there should be some follow-up. And in particular, in those cases, the individual has been noticed more than once, and commission should be made aware of those activities and take any additional steps they can to prevent further harm to the public.
Thank you, Nick. I'm going to refer that to advice counsel to get with staff, and that's an excellent point, and we will take that into consideration and see what we can do.
Yes, sir.
Thank you, Mr. Chairman.
Thank
Can I
you,
have a-
Nick. Question?
I just want
Question for Nick?
clarity, Mr. Camaradas. So you're saying that once a cease and desist is issued, you would like to see something actually in writing, or where we actually?
Yeah, ma'am. What I meant was, in a situation where a former licensee has lost their license,
Right.
either by order of revocation or termination, they've continued to engage in real estate activities.
Right.
The commission, another complaint was filed. The commission then files and orders a cease and desist, and the individual continues to engage in activity.
Right.
And in order to bring that new or continued activity to the body, another complaint has to be filed.
Okay.
And what I'm suggesting is that that extra step should not be necessary when you have a cease and desist already on the table.
Because I know we already have a lot of cease and desist continuing, so you're saying something else should be done where a complaint is filed?
There
No,
should be-
yeah, I think
Okay.
I think he's suggesting that after that cease and desist is issued, that staff should have some sort of regular interval where they are going back in and double checking to make sure that that person is not continuing to practice. So for example, not having a website advertising that they can provide real estate services or property management services. Am I correct on that, Mr. Kromitis?
Or in the alternative, if, have a process where evidence can be submitted without another formal complaint having to be filed.
Or the investigator can find, Google it and see it online. You have to go start all over again.
Just come directly to
I mean,
us.
and it's not a big ask. Fact of the matter is,
know.
like, for example, when we do office inspections, right? If the office is a disaster, you tell me we're not going to come back in 6 months? Of course we are. Why should this be any different?
Oh, there
It's
should be
more
a
severe.
follow-up
This should be more
process.
severe, so
Okay.
yeah.
I
There should
agree.
absolutely be an automatic follow-up. Again, if somebody, 6 months, a year later, I Google it, Fred, who we sent a cease and desist order, is back in business, then immediately the state should be able to problem and not go through the traditional.
Back to us, okay.
And for real estate agents, you just see this, we shouldn't have to say, go open another complaint. Just forward it to advice council, and they can send it to the
Exactly the point.
inspector and say, here, we received this. We have a.
And send it on up to the
Right.
administrative
We
judge.
shouldn't have to say, go open a complaint, and
No.
180 days later, we'll get something from
Right.
LRC on it.
Right, send it to the administrative court and call it a day.
So I do want to be really clear about one thing. There's a constitutional provision that requires those who make decisions about discipline to be separate from those who investigate them or prosecute them. So people should not ever send a complaint directly to me, because that would mean that I have to be recused from a case. It is also not helpful if they send it directly to commissioners, because then commissioners potentially have to be recused from a case as well, which that's part of why we have that complaint process. But we certainly can explore other options for whether there's a way for check-ins like that to happen at the investigative level. You know, and if something has happened, to refer that up to ODC. So I'll explore those options, see what we can and can't do, and get back with the commission. With the conference that we have coming up, it probably won't be till April before I'm able to get back with y'all on it, but I'll see what I can find out. If there's nobody else for public comments, I have one thing that I wanted to address. Yes, sir. So I just wanted to mention that we talked about the SCR article from April 7th of 2021 earlier that cited a real estate commission decision. That article was titled LLR says MLS disclaimers are not a defense. It's my understanding from the conversation that we had earlier that this is becoming kind of a widespread thing of agents listing things in the MLS and putting lots and lots of disclaimers in there, like, you know, we're not agreeing that the square footage is accurate, you need to measure it yourself. We're not agreeing that if we say it's 3 bedrooms, it's actually 3 bedrooms, you need to count them yourselves. And I just wanted to mention that SCR article, mention the decision that came out of. It is case number 2020-76. It is on the commission's website, with the date of November 13th, 2020, if anybody wants to read that decision for themselves. But you can put all the disclaimers you want on the MLS. That does not take you away from your statutory duties to do what you have to do to be accurate in your listings.
You're not discussing putting that
In the newsletter.
in the newsletter.
Yes, sir.
That will be forthcoming.
Yes, sir.
Any other comments?
Mr. Chair, I make a motion that we are excused.
Oh, we have a motion to adjourn. Do we have a second to the motion?
Enthusiastically second.
All right. Thank you. Thank you.